Okay, folks, I'd ask the cameras to clear, please. Et conformément à la...
And pursuant to Standing Order 108.2, we're going to continue our study of remediation agreements, the Shaw Cross Doctrine, and the discussions between the Office of the Attorney General and government colleagues.
From the Privy Council's office, Mr. Michael Wernick, the Clerk of the Privy Council and Secretary to the Cabinet. Welcome, Mr. Wernick.
Point of order.
Point of order, Mr. Cooper, yes?
Thank you, Mr. Chair. I would request once again that the witnesses be sworn in. Clearly, the testimony of Mr. Wernick, the last time he appeared before our committee, is in many areas inconsistent with the testimony that Ms. Wilson-Raybould gave. Given the gravity of the allegations and the very detailed testimony of Ms. Wilson-Raybould, I think that in the circumstances it is appropriate that both of the witnesses be sworn in. Thank you, Mr. Chair.
Mr. Cooper, I'll repeat what I said this morning, that no witness has been sworn in this committee for the last 25 years at least. That witnesses are required, and I'm reminding the witnesses, of course, they're required to tell the truth before committee. You can be charged with contempt of Parliament if you mislead the committee. But since Confederation, nobody has ever waived parliamentary immunity to charge somebody with contempt for misleading a committee. So that's why, out of practice, the committee has not done that. But we will have a vote per Mr. Cooper's a recorded vote by Mr. Cooper, certainly, and this would apply to both witnesses.
Both.
Okay. Okay. Mr. Clerk.
Merci.
By the way, so those voting aye are voting to swear in the witnesses. Those voting nay are saying it's not necessary. Mr. Clerk.
Monsieur Boissonneau.
No.
Mr. Assassi.
No.
Mr. Fraser. Ms. Khalid.
No.
Mr. McKinnon. No. Mr. Barrett.
Yes.
Mr. Cooper.
Yes.
Ms. Wright.
Yes.
And Mr. Rankin.
Yes.
Yeas pour, 4, 4, and nays contre, 5, 5.
Thank you very much. So that motion being defeated, I'm going to return to welcoming again Mr. Michael Wernick, who's the Clerk of the Privy Council and Secretary of the Cabinet. Thank you very much for coming back before us, Mr. Wernick. Et aussi à Madame Nathalie.
Also, we'd like to welcome Ms. Nathalie Drouin, who is the Deputy Minister of Justice and Deputy Attorney General of Canada. So thank you very much for being here today, Ms. Drouin.
Witness for opening statements, and we will start with Mr. Wernick. Mr. Wernick, the floor is yours. Oh, sorry. Before we start, excuse me, no time. We have Mr. Wernick's and Madame Drouin's opening statements that we have distributed to committee members. We also have the undertakings from Mr. Wernick from his last appearance before us to provide certain notes and correspondence that he had agreed to provide. We have those here. Some of them, much of it is bilingual, some of it is in English only. So I'm requesting the committee's permission to distribute it, despite the fact that some parts of it are not translated. Does the committee agree to have it distributed regardless? Everyone okay? Oui, Monsieur Plamondon?
Mr. Plamondon, I know that I can't object legally, but I'm very disappointed that we're not respecting one of the two official languages of our country fully. But I'm not opposed, since I don't have the power to do so, since I'm not a member of this committee. Mr. Beltud? Chair? This is the second time that this committee has not respected their responsibility to have documents in both official languages. We won't oppose these documents, but I would like you to inform all witnesses and members of this committee how important it is to transmit all documents in both official languages so that we can have access to the information in the language that we have the right to have access to it in. Generally, it's not the duty of the witnesses to do so. It's the duty of the clerk and the committee to translate the documents. And generally, we don't give everyone documents that aren't translated because it creates a time lag. And therefore, we asked if we were ready to distribute them beforehand. Chair, given the subject, I won't object. But what I would like you to do is to reiterate to the witnesses before they appear is to give us documents in both official languages, because this is the second time the committee has done this, and it would be important for this not to become a habit. Yes, we will accept unanimously to have these documents distributed. It's only so that everyone can have documents in time today, but I agree entirely that we want all documents to be in both official language. That is the practice of our committee. I hope that the documents will be translated in both official languages eventually. Yes, and given to all members. Yes, just for everyone to know, when we do receive documents, it's our responsibility as a committee to translate them, and we do distribute them afterwards. Sometimes, such as today, we want to have members to have access to these documents, but yes, of course, the committee will then translate them, and then they will be distributed in both official languages of Canada. So I understand, Mr. Plamondon, your concern, but I do realize that it's important today to be able to listen to the witnesses, and we have all the documents at our disposal.
Move to Mr. Wernick. We will distribute this, Mr. Clerk, and we will move to Mr. Wernick's testimony. Mr. Wernick, the floor is now yours. Thank you, sir.
Monsieur le Président,
Chair,
since I last appeared at the committee some 2 weeks ago, one is the waiver that was offered to witnesses so that will allow different lines of questioning by the committee members. And the other, apart from my cold, is the kind of traffic that I have received on social media. And I would like to present these to the committee. If somebody could please transmit them to the clerk. And I would ask the committee...
Point of order, what is the relevance of social media to what we're doing in terms of reference?
If I could explain...
Whether a line was crossed,
If I could explain...
Yep. Of course, Mr. Wernick. Go ahead. Stop time. Go.
I believe that you will want to discuss this as the intimidation of a witness before your committee and a breach of the committee's privileges. You can take that up in camera if you wish. I will be distributing these to the media.
Okay. Thank you very much. Since I haven't seen them, I'm not going to say anything right now. I just asked to move back to your opening statement, and the committee will consider it at a future date or when we're ready. Thank you very much, Mr. Wernick. Please go back on time.
Thank you. So, Monsieur le Président.
Chair.
Testimony to the Justice Committee on February 21st was partisan, presumably in content or motivation. I would like to respond. I would also like to provide the committee with my recollection of conversations I had with the former Attorney General. I want to first clarify my role within the Government of Canada as Clerk of the Privy Council. I am the Deputy Minister to the Prime Minister and Secretary to the Cabinet. In the first role, I'm charged with delivering advice to the Prime Minister and assisting him in delivering his agenda. I've had a close working relationship with the Prime Minister for more than 3 years, sitting in on countless meetings and discussions covering the entire range of government activity. I work at the intersection of the public service and the elected officials, and I am present for many discussions that touch on matters that some would see as political. It is my role to be aware of this context, but I do not ever give advice that is partisan in content or motivation. En tant que greffier, une de mes...
As clerk, it is part of my job to give the Prime Minister impartial advice and feedback on how his ministers are exercising their roles, their relationship with colleagues, and with the public service. The Prime Minister and his staff seek my advice before cabinet shuffles, and I have been the main advisor on appointments and deployments of deputy ministers.
My job is to ensure the smooth flow of decision-making through the cabinet system. The most scarce resource in Ottawa is time at cabinet, and I work hard to ensure discussions are well prepared, due diligence is being exercised, and options crystallized so that ministers in the cabinet room can focus on the key aspects of decisions before them. Part of my job is to keep the government's agenda moving. En tant que 23e greffier,
as the 23rd clerk, I have tried to be open with Canadians about my role and my perspectives. I communicate with them through a website and presence on Facebook, Twitter, and LinkedIn. All of my speeches are posted. I have given media interviews, and I have appeared before parliamentary committees. As head of the public service, I submit a report to Parliament and Canadians every year on the state of their public service. I have always tried to be direct in my language.
Disappointed to be accused of partisanship by people that have never met me. My career is on the public record. I have held the highest security clearances that this country can offer for many years. I was named to deputy minister level positions by Prime Ministers Chrétien, Martin, Harper, and Trudeau. I participated in the transition exercise, the swearing in, and the first cabinet meetings of Prime Ministers Martin, Harper, and Trudeau. I have attended more than 200 meetings of Cabinet and its committees since 1987. I have attended First Ministers' meetings with 4 Prime Ministers in the chair. I set this out because it's been suggested that I'm part of someone's political agenda. I serve the government of the day. So turning to the discussion at the Standing Committee on February 21st, my comments about the ethical conduct of the government, and previous governments for that matter, were not motivated by a desire to burnish their image. I have spent thousands of hours with politicians and political staff from all stripes, and I am in a unique position to attest to Canadians through you from personal experience that they are well served by the women and men who work in the offices of the people that they elect. Since I was last here, there have been a few developments. One is that several people have suggested I am more political than a public servant should be. I hope I've clarified that I understand my role in government. And the other development is the waiver and that the former Attorney General has testified. I will not respond to all of her evidence, but I do want to make a few points before we begin questions. My understanding is that one purpose of deferred prosecution agreements is that corporate criminality does not devastate workers, pensioners, suppliers, and others who did nothing wrong. This is in the criminal code, and it is part of public interest considerations. In speaking to the Attorney General in December, I was giving her contextual information about the SNC-Lavalin matter directly relevant to a decision she had to make. In dealing with the public interest, the Attorney General's decision is never final. The public interest can evolve and change, and the impact of a decision to prosecute or not prosecute was evolving in this case. When I mentioned to the Attorney General on September 17th that there was an election in Quebec, I did not do so out of any partisan consideration. That is an unfair inference. It is a long-standing convention for the federal government to try to stay out of the fray of provincial election campaigns and let the people of each province decide for themselves who they want to govern. In mid-September, based on the company's public disclosure obligations, I was concerned that a purely federal issue could surface in the last 2 weeks of that rather heated campaign. And it is my job to remind elected officials about those conventions. Lorsque je lui ai mentionné
On September 17th, when I mentioned that Quebec was in an election campaign, I didn't do so for partisan reasons. This is an unfair inference. It is a long-standing convention for the federal government to stay out of the fray of provincial election campaigns. In mid-September, based on the company's public disclosure obligations, I was concerned that a purely federal issue could surface in the last 2 weeks of that campaign. It is my duty to remind elected officials about those conventions.
In September and in writing in December that the decision about prosecution was always hers to take. The Premier Ministre a assuré le Procureur Général.
The Prime Minister assured the Attorney General in my presence in September and in writing in December that the decision about prosecution was always hers to take.
The cabinet shuffle was finalized, and the next day, in the context of calling 5 deputy ministers who were affected and would have to be ready by Monday, I called Madame Drouin and asked her to make sure that the new Minister of Justice and Attorney General would be brought up to speed on a number of prominent files that he would likely face questions about in the near future, perhaps as soon as the Cabinet retreat in Sherbrooke, which would begin on Wednesday afternoon, 2 days after the swearing-in. I mentioned carbon pricing litigation, the Norman trial, TMX, and SNC-Lavalin. I don't know if the Deputy Attorney General will agree with my recollection, but I never singled out SNC as the only issue, and it would be a misreading of my conversation with her to suggest it was. Je m'en tiens totalement.
I stand by my testimony of February 21st. And in terms of the testimony of the former minister on February 27th,
testimony, the following facts are not contested. She was always the decision maker. She was assured multiple times that she was the final decision maker. The former minister agreed that entering into a deferred prosecution agreement would have been entirely lawful. Je souligne que à la suite des témoignages de l'ancien.
I would like to note that after the former minister's testimony, the following facts are not contested. She was always the decision maker. She was assured multiple times that she was the final decision maker. The former minister agreed that entering into a deferred prosecution agreement would have been entirely lawful.
That her decision, a decision to take no action, was final in September. But she had the ability, as new public interest considerations emerged, to reassess the context and re-examine her reasoning, and that is the most she was ever asked to do. So I repeat my contention: the minister experienced lawful advocacy to consider doing something lawful in the public interest. I made no threats, veiled or otherwise, that the minister's decision would lead to consequences for her, and my position could be captured at all times by the well-known phrase, non-ingérence, non-indifférence. It is my contention the minister was doing her job, and I was doing mine. Je soutiens que la ministre remplisse.
I would like to repeat my contention that the minister the Prime Minister fulfilled his role.
Not say today. And I've been advised not to opine on the minister's reasoning or state of mind because some of the issues are or will be before the courts. So, my recommendation to the committee would be to develop an all-party report proposing improvements to the law around deferred prosecution agreements. Your recommendations could be adopted by the House in a single sitting day and become law before the end of this Parliament. This committee may also want to further explore the potential separation of the Attorney General function with a view to informing Canadians, and it would permit each party to take a clear position on this matter during the imminent election campaign. This is a profound change that could have consequences intended and unintended for decades to come and should not be rushed. Finally, this is the Justice Committee, and the committee may wish to hold hearings on the Attorney General of Canada's Directive on Civil Litigation involving Indigenous peoples, which she issued on January the 11th, 2019, effectively her last day on the job. This directive to all Government of Canada litigators could mark a profound change in Canada's legal landscape. However, it could be repealed or gutted at the stroke of a pen, and all that work turned to ashes. So I think now that all political parties need to be clear with Canadians on the future of that directive. That is my opening statement. I'd be happy to take questions from the committee.
Thank you very much.
Thank you for your patience.
Thank you very much, Mr. Wernick. We're going to turn now to Madame Drouin. Madame Drouin.
Bonjour, j'aimerais remercier.
Hello, I'd like to thank the members of the committee for allowing me to make this opening statement. My opening remarks will address my role and responsibilities as Deputy Minister of Justice and Deputy Attorney General of Canada, my professional relationship with the Honourable Jody Wilson-Raybould, and my chronology of events. As Deputy Minister of Justice and Deputy AG of Canada, I support the Minister of Justice and Attorney General and the government in the development of their policy objectives. In the exercise of my duties, my vision has always been the provision of high-value legal services. Given the traditional role of jurists, I would ask you to I always have a strategic alliance with customers, working as partners, focused on finding solutions and delivering results.
Of working with highly competent and impressive individuals. The former minister and Attorney General and I had a very positive working relationship. I commend her for what she brought and brings to Canada in her role in public office. I can tell you that I learned very much and a lot working with her, especially in terms of Indigenous issues and lawmaking. In fact, we continue the work she began at Justice Canada by taking a new approach to Indigenous litigation. I hold myself and my staff to the highest standards of providing nonpartisan advice. My role is supporting the ministers and Attorney General demands that I uphold the values and ethics expected of me, both as a public servant and as a lawyer. I would like to begin by describing my dual role as a Deputy Minister of Justice and Deputy Attorney General. I have been in this position since June 2017. In both these roles, I support the Minister of Justice in fulfilling his or her responsibility. My functions include giving legal advice and coordinating the legal advice given by the Department of Justice, supporting the development of legislation and policy that fall within the justice portfolio, as well as acting as the formal representative of the Crown in all civil litigation involving the Government of Canada. In addition to my support, the Attorney General of Canada is also supported by the Director of Public Prosecutions, who is also a Deputy Attorney General of Canada. The DPP and I do not report to each other. It is not my role to discuss specific prosecutions with her, and I have not discussed the substance of the SNC-Lavalin prosecution with her. However, I do provide advice to the Attorney General of Canada in her or his decision-making as to whether or not to issue directives to the Director of Public Prosecution or to assume the conduct of a federal criminal prosecution. In such situation, I approach giving legal advice in the same way I would when giving advice on any other statute, but with careful attention to the distinction between my job and the job of the DPP. Monsieur le Président,
Chair, by the scope of the Order in Council that was enacted by the Governor-General in Council on February 25th, 2019, I would now like to provide the committee with a detailed account of my interactions on this file. In order to provide you with this account to the best of my ability, I have reviewed my emails, files, and agenda. I have not consulted Ms. Wilson-Raybould, the Minister Lametti, or their staff, or anyone outside of the department on facts that are my own. My account will include details of the discussions that I had with the former Attorney General respecting the exercise of her authority pursuant to the Director of Public Prosecutions Act. September 4th. On September 4th, the department became aware of the Director's position to continue with the prosecution of SNC-Lavalin. I would like to clarify that on that I still don't know how or when the Director's position was shared with SNC-Lavalin. On September 5th, as I mentioned, I have reviewed my calendar to my best ability. My calendar indicates that on September 5th, I had a phone conversation with Paul Rochon, Deputy Minister of Finance. However, I cannot recall whether we talked about this file, another file, or both. Moreover, from what I can recall, that a first discussion that I had with Ms. Wilson-Raybould on this file was on September 5th, late in the afternoon. The purpose of the call was to discuss another file, but from what I recall, SNC was also discussed on the margins. The former Attorney General was in Fiji, and there was a 17-hour time difference. Two of her staff members, Jessica Prince, Chief of Staff, and Emma Carver, Policy Advisor, joined the call. We agreed that the department would provide advice on the role of the Attorney General for her consideration. I told them that the department had begun working on the advice the evening before.
For the 2 next days, my official and I developed a written advice. I also provided verbal advice to the AG staff, Emma Carver and François Giroux, on the Attorney General's power under the Director of Public Prosecution Act. I advised that it would be very important for the Attorney General to be comfortable with the Director position to not pursue a remediation agreement. I emphasized that the Attorney General was entitled to receive as much information as she considered necessary from the Director. It was during the course of these conversations with Emma Carver and François Giroux that they read to me the extract of the Section 13 letter from the DPP. For clarity, a Section 13 letter from a DPP to the Attorney General is to inform the Attorney General in a timely manner of any prosecution or intervention that the DPP intends to make that raises important questions of general interest. As I have explained to the committee, in fulfilling my role as Deputy AG, I am very careful to separate my role and responsibility from that of my counterpart, the Director of Public Prosecutions. As I have mentioned, I have no role in specific criminal prosecution. I am not privy to any of the evidence. This is why I refuse to review and receive the Section 13 letter. It was during the same conversation that Emma Carver informed me that she was drafting a document that she intended to provide to her counterparts at the Prime Minister office. I was also told that the Attorney General was not keen on the idea of exercising her authorities under the DPP Act. In her testimony, the former minister mentioned that I had conveyed information from the Department of Finance. To clarify, on September 7, I spoke with the Deputy Minister of Finance, Paul Rochon, and he had questions regarding the decision-making process and the roles and relationship of the AG and the Director of Public Prosecutions. Also, on September 7, I spoke to the former Attorney General's Chief of Staff and provided her a verbal outline of what we were drafting for the AG's consideration. On September 8, I provided a draft opinion to the former AG's office. The opinion is entitled, "The Power of the Attorney General to Issue Directives and to Assume Conduct of Proceedings." Sorry. The opinion begins with a discussion of the Attorney General's independence and her ultimate responsibility for criminal prosecutions. It describes the role of the DPP in much the same way I have explained to this committee. It also describes the power to assume conduct of a prosecution and the power to issue directive. The opinion also provides advice to the AG on the role of the DPP and that the AG is entitled to receive information from the DPP in order to understand the decision. Various options are set out in the situation where the AG either disagrees with the director's position or wishes to further assess the decision. These options include the issuance of directives that direct reconsideration or appoint a specific prosecutor to reassess. Another option covered is for the AG to decide to assume conduct of a prosecution, consider whether statutory conditions for remediation agreement are met, and if so, appoint an agent to negotiate such an agreement. The legal opinion also canvasses the possibility of seeking outside advice with respect to the AG's power under the Act and the Criminal Code in order to assess whether the conditions for a remediation agreement are met. The legal opinion advises that the relevant constitutional and statutory framework prioritize independence and transparency, and that any decision by the AG is hers to make independent of the political consideration or processes. There is also a short discussion of the deference by courts to prosecutorial discretion, which can be reviewed only for abuse of process. Je voudrais apporter un peu de contexte.
I would like to provide some context on this part of my remarks. While I've been at Justice Canada for almost 3 years, as you know, I also worked in Quebec in similar roles. During that time, I gained expertise in this area as I faced similar situations where decisions of a DPCP were publicly challenged and where an Attorney General was called upon to act. I appropriately brought this professional experience and expertise to bear on the advice my department provided to the Attorney General in this matter. September 10th, the department responded to 2 follow-up questions that we had received from the Attorney General's office as a result of the draft advice. On September 11th, the Attorney General's acting Chief of Staff, François Giroux, informed me by email that the Attorney General was not intending to intervene in the case and that she would be pleased to discuss it. On September 12th, the next day, the Department of Finance indicated to me that SNC-Lavalin was still in discussions with the DPP. I therefore understood that the DPP's position on whether to invite SNC to negotiate a remediation agreement was not final.
Or 19, and I would like to be more precise, but I don't have any evidence on that. I have a discussion occur with the clerk on the margin of a weekly meeting that we call the DM breakfast. I recall that I had a discussion with the clerk where we discussed options that the AG had available to her role, the DPP's roles, as well as my role. On September 16, I had a call with PCO where we would have discussed also the advice of the AG. To the best of my recollection, my first face-to-face meeting with the former Attorney General on this file was September 17, and I believe we may have only briefly discussed it on the margin of another meeting. I also saw the Minister on September 18 and 19. On September 18, the only purpose of the meeting was for the Minister to debrief on her meeting the day before with the Prime Minister. I do not recall her specific words, but I remember her telling me that the clerk was present. She also expressed to me that she was not comfortable with the content of this conversation. September 19. During my bilat on the afternoon of September 19 with the former AG, she told me that she just had a discussion with the clerk. During the same meeting, I clearly recall that the former AG said to me that this would be the last time we discussed the SNC-Lavalin matter, and she also instructed me not to have any discussion with the DPP. To the best of my knowledge, and to be clear, after September 19, I did not have any further involvement on this file with the Minister and her staff, with 2 exceptions. Je tiens à préciser qu'au meilleur de mes souvenirs,
I'd like to specify that to the best of my memory, my last contact with members on this file was September 19th, with 2 exceptions. The first of the exceptions occurred on October 19th when the application for judicial review of the DPP's decision was filed with the federal court. As would be regular process where there's an application for judicial review, officials in my department discussed with the DPP who should appear on behalf of the Crown. The second exception occurred near the end of the month of October. I do not have the exact date. The Privy Council office asked my department for an opinion on the potential impacts on SNC-Lavalin if the prosecution were to result in a criminal conviction. My department developed the draft legal advice. It was not provided to PCO at the request of the Minister's office.
in my chronology, I would like to return briefly to the time I first became aware of the January 14 shuffle. And again, I would like to, for the record, to say that I haven't discussed this testimony with the clerk. On Friday, January 11, the clerk of the Privy Council called to inform me of the upcoming shuffle. I was not told who the new minister would be. I proactively asked the clerk what areas or files I should be preparing to brief for the new minister. The clerk identified briefings the new minister and Attorney General on roles and responsibility as the primary need. This indicated to me that we were going to be receiving a first-time minister. The clerk also recommended that I brief the new minister on Indigenous files because the Prime Minister could ask the new minister to attend a meeting with Indigenous organizations early next week. He also recommended briefing the minister on current issues, including remediation agreement and SNC. As you are aware, SNC-Lavalin has sought a judicial review and the DPP decision, so it was a live issue for the new minister to be made aware of. To brief the new minister, I developed, with the assistance of my immediate team, a briefing handbook, which I am tabling here today. And je pense que vous avez les documents.
I think you do have the documents in French and in English.
In the handbook that the remediation agreement is also included. It was in this context that on the afternoon of January 11, I informed Jessica Prince, whom I thought was remaining the Chief of Staff, that we will need to brief the new minister on. Je vous remercie pour votre
Thank you for your attention. I know I went over my time a little bit, but I'm now prepared to answer your questions. Thank you very much for your testimony. I'd like to thank both of our witnesses, and now we're going to move on to questions.
We'll do 2 rounds. We'll see where the time is and ask people if they wish to continue. So for a 3rd round. So let's start with round 1 is 6 minutes to the Conservatives, 6 to the Liberals, 6 to the NDP, 6 to the Liberals. Mr. Cooper.
Thank you, Chair. I'll split my time with Monsieur Berthold.
3 minutes?
Yes,
okay.
Thanks. Madame Drouin, when you briefed the current Attorney General, did you advise him that the former Attorney General had made a decision not to overturn the decision of the DPP?
Thank you for your question. As you will know, there's a lot of things in the transition book. Whether or not I brief the new minister on specific subject is not covered by the waiver, but I think that you can have a flavor of the first briefings I had with him.
Thank you for that. You made, Mr. Butts in his testimony made reference to a legal memo from the Department of Justice that recommended seeking outside legal opinion. Is that memorandum the opinion that you made reference to on September the 8th?
This is my understanding, yes.
And who would have that been sent to, aside from the former Attorney General?
Donc, il a d'abord été remis.
So first, as I said, it was given to the Minister's office on September 8th, and I know that my teams sent it to the Privy Council office and to Public Services and Procurement Canada around or on the 10th or 12th of October.
To anyone in the Department of Finance? To Minister Morneau's office?
Pas à ce que je sache.
Not to the best of my knowledge. However,
opening remarks, I have discussed role and responsibility and authorities that an AG has under the DPP Act with my colleague at Finance.
And no, anyone in the PMO? Was it sent to anyone in the PMO?
I don't have direct contact with PMO, but as I said, my office sent it to PCO.
Now, just in terms of the decision of the DPP, there was some suggestion that Ms. Wilson-Raybould could have put something in writing if she decided she did not wish to overturn the decision. But in not doing anything, you would agree that the decision of the DPP would stand.
When an AG takes a decision whether or not to exercise his or her authorities under the DPP Act, there is no obligation to have reasons and to have written document for that.
Right, and so in not acting, the DPP decision would stand. Right. Okay.
Well, that's the conclusion. If they don't exercise, the DPP decision states.
Exactly.
Yeah.
Monsieur le Président, Madame Drouin, je vais...
Chair, Ms. Drouin, I'm going to repeat a few questions in French. First, I'd like to know, did you inform the new Attorney General of the position of the former Attorney General about the DPA or her ability to use her power to change things? I sent members of the committee the content of the topics for the first briefing and that myself and my team offered to Mr. Lametti. Now, in terms of the details of this briefing with Mr. It's not covered by the waiver. Is it the role of the Deputy Minister to inform the Minister of all the files so that they're aware of things and to make sure there's a smooth transition? It's your role to correctly inform them of this. Yes, thank you for your question. It really is part of the roles of Deputy Ministers. They have to prepare and welcome the new minister, and they have to give them all the necessary tools so they can get up and running as quickly as possible. And the decisions also that you tell them that they were made by their predecessors, these briefings on hot topics and current files don't necessarily include discussions about previous positions. It just gives a current state of affairs. I understand you can't say whether you told Mr. Lametti about the discussion with the former Attorney General because you haven't... it hasn't been waived. But yes, you did have to tell him about important files that concern his department. We have to bear in mind when you do a briefing with ministers, particularly when there's a change in government, deputy ministers don't delve into previous positions by previous governments. That's not part of the practice. I'm not talking about previous governments. I'm talking about positions of the current government. It's the same government. Response. The DPP had decided to move ahead with criminal prosecutions, but no decision had been made by the previous Attorney General. Thank you. Last question, yes. In terms of the memo, you said that it was at the request of someone. The two memos, actually. First one that was circulated, and the second about possible consequences. Who at the... Well, at this office asked you to do it. I did not have that information directly. Perfect. Thank you very much.
Mr. Wernick, Ms. Drouin, thank you for being here again. My question is for Ms. Drouin. I want to carry on talking about this memo of September 8th that you spoke of earlier ago. So from your testimony, I understand there was a number of general, there's a bit of general context as well as some specific options. Can you tell us what those options were?
Yeah, well, as I said, a couple of options. So the first thing, the memo said that an AG is entitled to receive as much information from the DPP concerning a specific case. The other option for an AG is to issue a directive, and then the content of the directive can be very broad. For example, to be concrete in that case, it could have been to give a directive to the DPP to enter into remediation agreement, or it could have been a directive to ask the DPP to revisit the decision or to reassess the decision. So that was one of the options. The other option was for an AG to decide to assume the conduct of the prosecution. And the other option was also to ask for a legal advice to the AG to decide whether or not she should exercise her authorities under the Act.
So was there a recommendation of one or more options to pursue?
I thank you for that question. I should have said that at the beginning. No. Okay.
Do you yourself have any concept of what would have been a preferred option?
I cannot have an opinion on that, and I would like to explain what. To have an opinion on whether or not a deferred prosecution should be offered in a specific case, you have to have in hand the evidence of the case. And as I explained to the committee, I'm not privy to the evidence, so I cannot develop an opinion on whether or not remediation agreement was appropriate in that case. I can explain to the committee that the offenses that SNC is facing are covered under the regime of remediation agreement, but whether or not it's appropriate in that case was a decision made by the DPP based on the evidence.
Okay. You also mentioned in your testimony that you incorporate legal opinion canvassing the possibility of seeking outside advice. Do you believe that's a reasonable course of action? In particular in a case like this where it's a brand new law, there are no regulations yet published, and this is the first opportunity to actually
so
make use of the law.
maybe two things. So remediation agreement regime is new, but also the DPP Act, the Director of Public Prosecution Act, is also kind of new. You know, we've been working with that system not for in Quebec almost 10 years now, but at the federal level I think it's 8 years. So we don't have any precedent. We don't have any case where an AG has used his or her power to issue a directive.
Okay. Did you think that despite the decision of the PPSC to not pursue a remediation agreement, that it was still reasonable for that option to be considered by the Justice Department and the Attorney General?
As I said, I cannot have an opinion, because to make an opinion on whether or not a DPA or a remediation agreement is an option on a specific case, you have to be aware of the evidence, and I have never been aware of the evidence.
I guess I'm wondering if the fact that the DPP has made a decision, would that in any way preclude the AG from taking action?
Oh, well, thank you for make it your question a little bit clearer for me. No, the AG, as I said, has authorities under the DPA, the DPP Act to intervene, to issue directives or to decide to assume the conduct of a specific prosecutions. But it's her decision, as I said at the beginning, to decide whether or not to use those authorities under the Act.
Would such an action on behalf of the AG in any way constitute interference?
Well, the fact that an AG decides to exercise her authorities under the Act is not an interference, because there are powers provided under the Act, especially if we respect the parameters, the first one being the consultation with the DPP before exercising any authority, and the second one to publish the directive or the decision in the Canada Gazette.
Okay. So back to the memo.
Last question, Mr. McKinnon.
Thank you, Chair. In that memo, was there any recommendation to undertake consultation with other government departments that might be affected?
No, the memo didn't contain any recommendation.
Okay.
Thank you very much. Mr. Rankin.
Thank you. I start by saying, Mr. Wernick, that when you testified here previously, I thanked you for your 37 years of public service to Canada, and I reiterate that today. I live in Victoria, BC. No surprise to you that there are many retired senior public servants from the federal government who've called me over the last while. And I have to tell you, sir, that to a person, they expressed deep concern about the line that I suggest you've crossed. Today you said that you never give partisan advice, you don't engage in partisan activity, You're not part of someone's partisan agenda, and you're not motivated by burnishing politicians' image. However, when you appeared before us last time, you did the following. You started by talking about an assassination. You talked about fear of your country, which Professor Wes Wark characterized as the politics of fear. And then you turned and talked about extemporaneous praise for Minister Carolyn Bennett. Finally, today, you brought in a number of social media comments with great respect that have nothing to do with what's before us. Mr. Gordon Robertson, the Dean of Clerks, said this in a 1971 article: "The Prime Minister's office is partisan, politically oriented, yet operationally sensitive. The Privy Council office is nonpartisan, operationally oriented, yet politically sensitive. The clerk and the PMO must keep out of each other's way." Sir, with great respect, how can we have listened to your testimony last time, and of course, if we believe Madam Wilson-Raybaugh's testimony, do anything but conclude that you have, in fact, crossed the line into partisan activity?
I can only repeat, I state categorically that I have never given advice or done anything for partisan purposes, which would suggest to advantage one political party versus another in the political arena. So the attempt to change the channel last time, so the headline would be about assassination and the like, the attempt to talk about a minister who has nothing to do with this matter and how terrific she served Canada, we're to assume from that 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 was just something you wanted to get off your chest at a discussion of the Shawcross principle? I was aware of the punditry and media traffic and social media traffic that had been triggered around this issue. I stand by every word I said in the opening statement. They come from a deep place of concern about this country, and I repeat them. I have had the highest security clearances of this country, and I am deeply worried about foreign interference in the election. If that was seen as alarmist, so be it. I was pulling the alarm. We need a public debate about foreign interference. So we do. I am never accepting that we would normalize the cyberbullying of political officials. I have been exposed to it. It upsets me and it angers me. And I am upset by the trolling that took place of Minister Bennett. I stand by that. That was not to the partisan advantage of the Liberal Party. I deplore the cyberbullying of politicians of all stripes.
Thank you. So do we all, although what that has to do with this is a little unclear. On December 19,
it may have to 2018, do with the intimidation of a witness.
On December 19, 2018, we had a number of comments made by Madam Justice Wilson-Raybould about yourself, and I want to give you the opportunity to refute them. Number one, you're quoted as saying, "I think he is going to find a way," speaking about the Prime Minister, "to get it done one way or the other. So he is in that kind of mood, and I wanted you to be aware of it," close quote. Did you say that? Or words approximating that?
I do not have an independent recollection of the event. I did not wear a wire, record the conversation, or take extemporaneous notes.
So you wouldn't have stuck in your mind words like that?
That is not my recollection of the conversation.
Then she said she warned you in this call that we were treading on dangerous ground. "I also issued a stern warning because, as the Attorney General, I cannot act in a manner, and the prosecution cannot act in a manner that is not objective, that isn't independent. I cannot act in a partisan way, and I cannot be politically motivated. This all screams of that," close quote. Sound right?
I do not have contemporaneous notes or recording of that conversation. I recall the sentiment, and I agree with it. Nobody was ever asking her to do anything for partisan reasons.
The clerk said that the Prime Minister is quite determined, quite firm, but he wants to know why the DPA route, which Parliament provided for, isn't being used. "I think he's going to find a way to get it done one way or the other. He's in that kind of mood." Can you not see that she might reasonably interpret those words, if they were in fact made, as code, as a sinister effort to get her to change her mind? Couldn't a reasonable person hear that and conclude, as she did, that it was very much a veiled threat?
I am in no position to comment what was in the mind of another person. I can only comment on what I was conveying to her, which was context, and public interest considerations on a decision that was entirely hers to make.
So entirely hers, pardon me?
Last question.
So entirely for her to make, but you certainly tried, it seems to her, to have changed her mind in a way that would cross the line that we're here to explore. She took it as a veiled threat. When I read it back to you, I think a reasonable person could likewise infer that it was a veiled threat. And it seems to me, sir, you very much crossed the line in respect of an independent Attorney General.
Respectfully disagree. I never raised partisan considerations at any time. I reminded her repeatedly she was the final decision maker. I did not attempt to influence her decision. I was giving her relevant context about public interest considerations for a decision that was hers to take, and I never suggested consequences for her.
Thank you. Ms. Khaled.
Thank you, Chair, and thank you to the witnesses. Ms. Drouin, if I may, according to the former Attorney General, you had refused to accept the Section 13 note from her, and you have confirmed that as well. And the former Attorney General said that she'd been concerned because it's not appropriate for public servants to get involved in political discussions. Madame, why did you refuse the Section 13 note?
As I said in my opening remarks, this is not my role to evaluate and to have access of specific evidence on specific prosecution cases. As I said, it was during that conversation with our staff when we discussed about the importance for her to be convinced that she did receive all the necessary information for her to make the decision that some extract of the Section 13 letter was read to me. But because it is not my role, I didn't ask and I didn't want to review the letter.
Would receiving the Section 13 note have been in violation of your role as the Deputy Justice Minister and the Deputy Attorney General?
No, I won't say it's in violation, but it's not part of my role.
Was your refusing the note akin to you getting involved in political discussions, as the former Attorney General has said?
So I have trouble sometimes when we use the word political or partisan, using the same thing. But as I said, I had a conversation with some colleagues. I responded a lot of questions about my role, the role of the DPP, the authorities of the minister under the Act, what she can do, what she cannot do, why taking a decision in a prosecution is not the same thing as an AG as taking a decision in a civil matter. For example, the fact that she wears a quasi-judicial or judicial hat when she takes a decision. That was the type of conversation I had with my colleagues.
Thank you. Do you believe that the former Attorney General tried to exclude you from discussions on this specific issue because she disagreed with your views?
No, I didn't feel that she excluded me for that. The former minister has a strength of character. She possesses a strength of character and integrity. She upholds her independence. She has very solid view of her independence. And I think this is why she was not comfortable to enter into discussion that can interfere with the decision she has to take.
Thank you. And that leads perfectly into my next question. The former Attorney General had said that she raised concerns with you about the appropriateness of communication that she was receiving from outside the department, and that she raised concerns about some of the options that you had been suggesting. What did she mean by this, and which options were you suggesting that she felt concerned about?
Well, first, as I said in my opening remarks, she told me that she was not comfortable. And she didn't appreciate her conversation first with the PM, and then she asked me not to talk anymore about the SNC-Lavalin case and also the authorities under the DPP. I think this is what she means by, she talked to me several times about the fact that she didn't want to have those conversations. What was the other part of your question? Sorry.
We were talking about which options what were they that you were suggesting that she felt concerned about?
So as I said previously, we didn't recommend any specific options. We just exposed all the options she had in front of her. She didn't want to exercise, that was her decision not to exercise any of those options.
So there were a lot of options before the former Attorney General. Do you think and do you believe that she had an open mind to those options that were in front of her?
In all my discussion, in any files with the minister, she was always open to receive information, to seek advice, and then it was for her to take decisions.
So we understand that from September 4th to September 16th or 17th was when the majority of the options were put in front of her, and we had those discussions. And for a majority of that time period, she was not physically in the country either. Do you think that that is a reasonable time frame for her to have come to the final decision that she came to?
I think it's not for me to assess. As I said, and she did say in her testimony that she did her due diligence. I was not part of that due diligence exercise. And as I said, in order to make a decision, yes, she has to take into account the context, but she also have to take into account the evidence and the information she got from the DPP.
So the evidence and the information that is ever evolving in a live case like this one.
It's the role of any public prosecutor to continuously assess the public interest on whether or not to continue a specific case. But of course, this continuum, if I may say, obligation depends on new facts or new evidence that can be submitted to the prosecutor.
Last question, Ms. Khaled.
Thank you. Ms. Drouin, did the former Attorney General ever share with you her views on remediation agreements in principle? And if so, what was it?
Well, the remediation agreement was, developed, and it has been discussed in this country for many years. We did a consultation in the fall of 2017. We received many submissions. I'm sorry, I don't have the specific numbers. We issued a document to summarize all the submissions we received, and the remediation agreement, I think we have said that many times. It's another tool in the toolbox in order to do enforcement, and particular regarding financial crimes or white-collar crimes. But again, it's not because you have a tool in the toolbox that the tool is available for any task.
Thank you very much. We'll now move to the second round of questionings, which goes 6 minutes to the Liberals, 6 to the Conservatives, 6 to the Liberals, 5 to the Conservatives, 3 to the NDP. So, Mr. Rankin?
Just a point of order. Is this going to be the last round, or are we going to be able to ask these witnesses to continue?
So my intention is at the end of the second round to ask people whether or not they wish to continue. And I think the question, I think right now we're at a time, what time is it now? Sorry. 1:06. I think we'll be able to fit in a third round before the meeting expires, which is at 4 o'clock. So we'll move to the Liberals now. It's Mr. Fraser.
Thanks very much, Mr. Chair. Thank you both for being here today. Madame Drouin, I'd like to just go back to your opening comments with regard to what you said about September 12th. I understand that you had a conversation with the Department of Finance on September 12th, that SNC-Lavalin was still in discussions with the DPP, and you said, I therefore understood that the DPP's position on whether to invite SNC to negotiate a remediation agreement was not yet final. Did you have any reason to believe by September 17th that those discussions had concluded?
I don't have that information.
Was it your understanding from that
The only thing I can offer to this committee, and I really rely, I said also in my opening remarks that I don't know how and when the DPP informed SNC-Lavalin about the final decision. The only thing I have is the public record when SNC publicly announced, I think it was in October 10 or 12, that the remediation agreement has been turned down on them.
But by September 17th, it's possible that the discussions were continuing with the DPP and the Department of Finance.
I don't want to do any hypothesis, but I don't have the information to confirm or deny what you're saying.
Okay, fair enough. I understand that you basically are alluding to the fact that the former Attorney General was not keen on intervening or to look at this further as early as 2 days after receiving the Section 13 notice, as I understand the sequence of events. So I guess that would be as early as September 11th. So that would have, she had expressed that she was not interested, perhaps, or not keen on exploring that possibility while discussions were still ongoing between the Department of Finance and DPP. Is that accurate?
First thing, several elements in your question. On September 11th, I did receive an email from his then acting chief of staff saying that minister was not, the email was in French, let me read it, please.
Yeah.
That the AG did not have the intention to intervene in the file, but that she was open to discuss it with me.
In your question, maybe I misunderstood, but I don't know. I don't think that finance has never had any conversation with the DPP. Maybe I misunderstood your question, but the DPP and finance has never discussed together. Maybe SNC had discussion with finance,
yeah.
but not the...
So according to the Department of Finance, the discussions between SNC-Lavalin and the DPP were continuing as of September 12th. And
this is the information I got.
And that email you had received on September 11th was that the take of the Attorney General at the time was not to not keen on looking further at that matter.
That's my understanding. Yeah.
Okay. J'aimerais tourner à...
I'd like to move now to a question in French. Were you aware of the concerns of the former Attorney General in terms of the deferred prosecution agreement, in terms of the public interest? I don't think there was concern. DPAs are tools. They're interesting tools. As you know, I applied the law in this area for financial crimes. I know it's a very interesting tool, and it is one that is available for all types of situations, and it's a tool that allows, to make corporations responsible for their actions, and we can repair the damage they did to the victims, but at the same time, we avoid re-victimizing other innocent third parties, such as employees and pensioners and shareholders and small shareholders. Nevertheless, this tool is available, and I think it is an advantage for Canada to have an additional tool for criminal proceedings, and it's always up to the director of criminal proceedings to decide whether it's a good tool or not, taking into account several factors, including the severity of the crime, the people who were involved in the crime, other investigations that an entity may be involved in. So there are several components that the DPP has to take into account. But to summarize, yes, it's a good tool, but it is up to the DPP to decide and to make the decision whether we should use it in a particular situation or not.
I had mentioned that on September 17th, that by that time she had made up her mind, and that she says, I quote, "For those who know me, I was not going to change my mind." Do you have any view or comment with regard to a usual practice of an Attorney General of not considering new information coming forward?
Well, I think what I would like to say is that when the DPP Act were developed, it was clear for everyone that the authorities under the Act should be used on an exceptional basis, not to put in danger the independence of any prosecutors. So I think this is why we don't have any precedent at the federal level, nor in Quebec, where we do have a similar regime. But that doesn't mean that it should never be used, but it should be used with a lot of careful.
Okay.
Thank you.
Thanks.
Mr. Polyev?
Mr. Wernick, on September 17, 2018, in your presence, the Prime Minister told the Attorney General that if there was no deferred prosecution agreement, that SNC will move from Montreal. Did the Prime Minister know at the time that a financing agreement with the Caisse de dépôt made it impossible for SNC to move its headquarters before the year 2024? Yes or no?
That is not my recollection of what the Prime Minister said.
So he did not say that the SNC will move from Montreal if it does not get a deferred prosecution agreement?
That's not my recollection of what he said.
All right. How about let's turn to what you said. Hopefully your memory is a little better on that. At the same meeting, you told the Attorney General that there would be a board meeting of SNC-Lavalin within 3 days, and they will be likely be moving to London. Who told you that SNC would likely announce a move of its headquarters to London at its September 20th, 2018 board meeting?
That is not my recollection of what I said.
Are you certain that you did not say it?
That is not my recollection of what I said. If I could explain, if you're interested in the answer, the company was operating under disclosure obligations at all times as a publicly traded company. In mid-September, the company was approaching a requirement to divulge to markets what was going on because it was 90 days after the DPP legislation had been passed. So an announcement by the company was imminent, and an announcement by the company was imminent at regular intervals through the fall and the winter because of their obligations to markets.
And when did that announcement come?
The track record of what the company said and when is on the public record. I'm not aware of that.
Okay. Also, at a December 2018 meeting, you, Ms. Raybould says, you said, and I quote, you spoke about the company's board and the possibility of them selling out to somebody else, moving their headquarters, and job losses. Did you say that?
The options open to the company were a matter of public record in the business press.
Yes,
if I could finish, sir. If I could finish, sir.
It's just that here's the problem. The public record was clear that they were not moving their headquarters. That was the public record. Anybody who could use Google could find shareholder disclosures showing the company had to stay in Montreal for at least another 6 years. And when you said on December 19th that the company was moving its headquarters if it didn't get a DPA, that was 2 days after the Toronto Star reported that the CEO said the company is, quote, committed to remaining headquartered in Montreal. How is it possible that you didn't know that 2 days earlier the company had publicly stated its plans to stay in Montreal when you told the Attorney General the opposite?
So you will know, sir, that it is possible for a company to retain a shell headquarters in a city and move the guts of its operations somewhere else.
But that's not what you said. You said that the headquarters would move.
That is not my recollection of what I said. I never said at any point in any conversation this is what the company will do, because I would have no knowledge of that. I would know that there was potential risk of a number of outcomes from the company. I had communications with the company on September 18th in the afternoon, and I've just provided the committee with the notes that were taken of that meeting. And I took a call from the chair of the board on around 11 o'clock in the morning on October 18th. Those are my sole communications with the company.
But with respect, your suggestion that the headquarters would become a shell is also impossible because the loan agreement with Case requires that the CEO, all the senior executive, all the decision-making, a large number of the board members would have to stay in Montreal. It was also public knowledge the company had just signed a 20-year lease in Montreal and announced massive and costly renovations to continue to house its HQ in Montreal. And the CEO had said publicly that he was staying in Montreal. Knowing all of that public information, why did you say precisely the opposite to the Attorney General?
That is not my recollection of what I said. And
did you say anything about moving the HQ?
If I can,
did you say anything about moving the HQ to the Attorney General? Yes or no?
Mr. Chair, I would ask you for the ability to answer questions.
Please let the witness answer the question on this.
I would welcome that.
Go ahead, Mr. Wernick.
Fact number one about the entire file is that the case is going to trial, and there is a prosecution underway. The possible outcome of that is a conviction, which would bar the company from public infrastructure contracts across the country and possibly in international markets. So the company was and is at risk.
Yes, but once again, my question, very simple. Did you or the Prime Minister ever tell the Attorney General that the headquarters would move if she did not sign a deferred prosecution agreement?
No.
Yes, you did not?
No, I did not.
Okay, thank you. And now that I have 20 seconds,
yep, you do.
Were you aware that the government was working on a provision to allow SNC-Lavalin or companies like it that are convicted to continue to bid on federal contracts? Yes or no?
These are not yes or no questions, sir. It is well known that...
To finish the answer. Go ahead. Even though the time's expired, please, Mr. Wernick, finish the answer.
So the law was brought into effect over the spring and summer of last year. It finally was brought into effect, I think, in mid-September. Like many pieces of legislation, it would require implementation regulations and protocols. And it is a matter of public record that there were extensive consultations, which are still underway, by the PSPC department about implementation of the law. Those were done in the public domain, the input is there, and the Minister of Public Services and Procurement has not pronounced and issued those regulations. The purpose, as I understand it, was to make sure it wasn't a binary choice and that there would be options available to a government in terms of the consequences of a conviction, a ladder of sanctions.
Thank you very much. Mr. Assassi.
Thank you, Mr. Chair. Thank you, Ms. Drouin and Mr. Wernick, for reappearing before this committee. It's been very helpful. Now, my first question is for Madame Drouin. On pages 10 and 11 of your opening remarks, it says that I was told by a policy advisor in the Attorney General's office, quote unquote, that the Attorney General was not keen on the idea of exercising her authorities under the DPP Act. Now, to me, looking at the date, that the day this would have happened and the day you were informed of this was 2 days after the notice had been issued. Was any reason provided to you as to why the Attorney General did not wish to exercise her authority under the APP Act?
So maybe, as I said to your colleague a little bit earlier, so those authorities under the DPP have never been used. So there is a risk that for any AG to use in any circumstances the authorities under the Act being perceived as political interference.
So, no, was any reason provided to you as to why they were?
Well, I think the reason was that the former AG didn't see any room or marge de manœuvre to use those authorities without being perceived as politically interfering in a case.
And in your opinion, was there any room to interfere?
I'm not here to provide any opinion to the committee. As I said before, the powers or authorities are under the DPP Act. It was clear when they were adopted that they should be used on an exceptional basis. And it's for the Attorney General to decide and to make a decision on that.
Now, we've heard from the clerk in his statement. I'd like to quote this passage. He says, "In dealing with the public interest, the Attorney General's decision is never final in the sense that the public interest can evolve or change." Putting on your legal hat, would you agree with that assessment?
I agree that it's the responsibility of a prosecutor. It's a continuum obligation to assess and reassess the public interest regarding a specific prosecution in light of, new facts and evidence put in front of the prosecutor.
So as the factual matrix evolves, you would think that there's an opportunity to revisit. That would be the obligation, essentially.
Sorry, can you
That
repeat
would be the obligation to actually...
It's a continuum assessment, if I may say, in light of new facts or evidence put in front of the prosecutor.
Thank you. Now, another question I have for you is, would you agree that the discretion of the DPP is decidedly distinct and different from the discretion of the Attorney General?
Well, the first discretion, and that should be 99% of the case regarding decision to lay charges on specific cases belong to the DPP. And the discretion of the AG is whether to decide on an exceptional basis to overturn, change, or modify the decision of the DPP, respecting the obligation and the parameters under the DPP Act.
Thank you. Now, last time you appeared before this committee, you actually brought up the BAE decision, which has to do with discretion, and how the House of Lords, which was grappling with some of the same issues we've been grappling with, how they dealt with it. Did you ever have an opportunity to discuss the BAE decision with either the Attorney General or her staff?
I did not discuss the Corner House case with the former DPA, with the former AG. Sorry.
Thank you. Now, if I could turn to the clerk, how unusual is it for the clerk or the PM's deputy minister to speak to a minister on issues where there is friction between different and distinct ministries?
It doesn't come up very often in a cabinet of 30, 35 people. As the Secretary of Cabinet and the Prime Minister's deputy, I try to keep the flow of business through Cabinet going, and I'm very watchful for relationships among ministers and public servants. The Prime Minister doesn't always have line of sight to that. And so there are occasions where I will speak to ministers or speak to officials to try to, I guess the word might be conciliate or find a way through because they tend to chew up time and energy, and my role is to keep the agenda moving forward. I don't do it very often. I have done it from time to time over the last 3 years. And this was a case where I could see that there was a building tension and frustration about this issue.
Thank you. Now, last time you appeared here, you testified that to the best of your knowledge, there was no improper pressure applied to the former Attorney General. In light of what we've heard from witnesses since your last appearance, would that still be your assessment?
Yes.
Thank you.
Thank you. Ms. Reid, 5 minutes.
Thank you, Mr. Clerk. Mr. Clerk, why did Mr. Butts say this morning that he was able to get access to his own emails within days of his needing to come to this committee, but Mark Norman has had to go to court to get access to his own emails?
I'm not sure I even understand the premise of the question.
Okay. Then let's try this one. Mr. Wernick, you have given incredibly conflicted testimony, and I'm going to take you through some of it. The crux of the issue, according to Mr. Butts this morning, was what and when did the Attorney General, the former Attorney General, tell the Prime Minister himself or you that she had made up her mind and she was not going to change it? Now, I asked you that question when you were here last. You didn't give an answer specifically, but we ended up settling on September 17th. Would you now say your testimony is you found out from the Attorney General, former Attorney General, that she had made up her mind on this issue by September 17th?
I accept that on September 17th, in her mind, she had made a final decision. In law, the decision was never final because she could always take into consideration public interest considerations and was able to take into account new information.
Okay. Mr. Wernick, you have provided for us your contact with SNC-Lavalin. I find it very helpful, and I want to thank you for it, but I am troubled by one thing. You went to great lengths of telling us in your last testimony about how you had only a few meetings with them, and indeed that you had several email requests for a meeting on September 18th, the meeting you took. You registered it. Then you told us about running into SNC executives at the NAC Gala and that you left right away. Indeed, the clerk contact also indicates there were further requests for more meetings until October 15th. And you took a call from the former clerk of the Privy Council, Kevin Lynch.
I believe that's the 18th.
I have October 15th here in this, whatever the date was, the date is this.
Whatever the date was.
Here's my concern. Here's my concern. You rejected everybody else in terms of speaking about SNC-Lavalin, but you took the meeting from the former clerk of the Privy Council. And my concern is this. Section 33 of the Conflict of Interest Codes sets out exactly what a previous office holder can and cannot do. And what it says is, no former public office holder shall act in such a manner as to take improper advantage of his or her previous public office. Now, you rejected all SNC. You told us with great glee that you walked out of an important dinner that you wanted to go to because you didn't want to be seen with them, and yet you took a call from a former clerk. Do you have concerns that the former clerk breached his duties and obligations to Canada?
No.
You don't think that you took the call from Kevin Lynch because he was the former clerk of the Privy Council?
No.
Why did you take the call from Mr. Lynch?
Mr. Lynch was the chair of the board. I knew this was an active issue in October. I took the meeting with the company. They are not a pariah. It was not improper to have communications with the company. The conversation was a telephone conversation, not a meeting, and it lasted less than 10 minutes. Mr. Lynch, as the chair of the board, expressed his frustration that he did not understand why a DPA was not being considered, and he knew that the board, in its trustee relationships for the shareholders in the company, was going to have to take some tough decisions in October and November. My recollection of the conversation is he asked, isn't there anything that can be done? And I told him in the firmest, curtest possible terms, no, he would have to go through the Attorney General and the DPP through his counsel.
Wow. So not more than 2 weeks ago, when you gave your first testimony about having no contact with SNC, you said nothing about this phone call, and yet today
I was cut off, if you recall, Ms. Raitt. I was proceeding to read the chronology, and I was cut off with it incomplete and undertook to provide the chronology to the committee, which I have done.
Well, thank you for cutting me off, Clerk. But as I was going to say, I think it's incredibly pertinent, and you must have had a knowledge of it because you gave us almost a verbatim right now about what the content of that telephone call is. Can you not see how disturbing this could be for Canadians to see that former clerks who are now chairs of boards of SNC-Lavalin have easy access and immediate access into the central office of this government, into your office, when you turned down everybody else and walked out of a gala because you didn't want to see SNC anymore? Do you not see that as a problem for this country?
No.
We've exhausted the 5 minutes on that one. We will go to Mr. Rankin.
Mr. Angus, go, and I'll take the next round.
Okay.
Thank you.
Thank you. Mr. Wernick, I'm looking at your statement, and I find it pretty thin gruel, given the fact that 5 former attorney generals have asked for an RCMP investigation. Former Liberal Attorney General Michael Wernick said he's never seen such, quote, brazen and reckless interference in an independent prosecution. We have had 2 cabinet ministers resign. Ms. Philpott saying she had constitutional and ethical obligations in the face of political interference. You are one of the key political actors in this, Mr. Wernick, and yet I find that's missing from here is any attempt to explain what happened in that key meeting of December 19th, where we asked Ms. Wilson-Raybould on record if you threatened her. And she said she wasn't threatened once. She was threatened 3 times by you. And then she said that you wanted to find a way to talk directly to the prosecutor, which would be the interference, direct interference in the prosecution case. And she warned you that you were on dangerous ground. How come you haven't even tried to rebut her testimony?
I haven't been asked the question, Mr. Angus. I do not have independent recollection of what I said. I did not record the conversation. I did not wear a wire. I did not take contemporaneous notes. And that is not my recollection of the way the conversation flowed.
Can I put it to you, Mr. Wernick? You're asked about threatening the Attorney General. You're asked about treading on dangerous ground, and you tell our committee, well, I wasn't wearing a wire. Sorry, I don't remember. Mr. Wernick, that is not a credible answer. You are to be the clerk of the Privy Council. If you come to a meeting and you can't remember threatening the Attorney General and tell us, well, I'm sorry, I wasn't wearing a wire, I suggest, Mr. Wernick, that the brazen and reckless interference referred to by 5 former Attorney Generals refers directly to you. And if you cannot answer that question, you have no business being in that job.
So I have said at this committee before, and I would say again, I did not threaten the Attorney General.
But you don't remember. You told us you don't remember.
I am telling you now, Mr. Angus, if
you don't remember.
If you want the answer,
finish the answer to the question. Mr. Clerk.
I have never raised partisan considerations. I reminded her repeatedly she was the final decision maker. I did not attempt to influence her decision. I was giving her relevant context about public interest considerations. I did not suggest any consequences for her. I made no threats to the former Attorney General.
Well, so
period.
now you remember. But I will just end on this. She said she expected the Saturday night massacre, which is a reference to Richard Milhouse Nixon and the firing of the special prosecutor. And lo and behold, she was replaced 2 weeks later. So I think Ms. Wilson-Rabel's testimony is very credible, and I'm very sad that you get a second kick at the can, and she's not being given a chance to rebut what you're saying today.
Thank you.
So, Mr. Chair, if I may,
Mr. Wernick, yes, you may respond to
quickly. I note that many members at this committee have said they believe every word of the former Attorney General's testimony. Part of what she testified is she does not believe that any behavior crossed the threshold of criminal behavior. So that was her testimony.
That's the bar? It's not criminal?
That was her testimony.
Okay,
that was her testimony.
Okay. Thank you. Okay, no cross talk back and forth. Thank you very much. So that concludes. Okay, so guys, this is not now a time for debate. This is now a question of whether or not we move to a third round. I think there's sufficient time for one more round. Does everybody agree? And do we agree again that at the end of this round we give 3 minutes to each of the three other parties here? Perfect. So in the third round, we move first 6 minutes Conservative, 6 minutes Liberal, 6 minutes NDP, 6 minutes Liberal, and then 3 minutes to each of the other three interveners. So will this be Ms. Wright?
I'm going to refer Mr. Wernick to the documents that you provided to us this afternoon that we had requested last time, and I'm wondering if you can give me a little bit of help with the handwritten notes. Do you have a copy of them there?
I believe so.
Great. The handwritten notes of your COO, Deputy Secretary to the Cabinet. Midway down, it says we're looking forward to DPA, and this is what SNC-Lavalin says. Initial indication with Minister is to discussion. Can you give me a little bit more color as to what's being said there?
I believe these are the words, transcription of the words from the company.
Yeah. Do you recall what the comment was there?
Which part are you referring to?
Initial indication with respect to, I can't make out what the rest of it is. I'm wondering if you can help us.
So what the notes allow us to confirm is that on September 18th in the afternoon, the company had not been informed by the DPP that a DPA was going to be declined.
Okay. Interestingly enough, that is not what the legal officer to the DPP said in her letter to SNC-Lavalin. I understand.
That's what the company said.
Sure. You also provided for us the clerk contact with SNC. Is this everything in the contacts now? You're content that it's the entirety of your interactions with SNC-Lavalin?
It's everything that I'm aware of. When the Ethics Commissioner began a process, which is some time ago, there was an immediate request for all documents and records remotely related to SNC-Lavalin to be secured, and they were secured and they were sequestered. And that is probably, now that I think about it, why Mr. Butts's email traffic was secured and sequestered.
Glad you understand the question now. So in your testimony previous, this. You said that I asked you if you were informed of the September 4 decision by the Director of Public Prosecutions. You said no. And then by midway of your testimony, you indicated, I think she advised the Prime Minister of her view that a deferred prosecution agreement was not a good course, and she had no intention of intervening, and indeed, she has never intervened. So, as I said before, we're on safe ground to say that you and the Prime Minister both knew on September 17th that she had made her final decision and had no intention of intervening.
And as a matter of law, the decision is never final because she could always take into consideration public interest considerations and was able to take into account new information.
Okay. I appreciate that. Are you a lawyer, Mr. Wernick?
No, I'm not.
Okay. Who wrote that for you?
I have retained personal counsel because Mr. Scher's letter to the RCMP.
Right. So you're telling me that your lawyer wrote that for you?
My lawyer advised me on the boundaries of my testimony this afternoon.
Yeah, but what you just read there is interesting to me about making the assertion that everything was okay. I'm wondering who wrote that for you, because it sounds an awful lot like some other comments that were mentioned by Mr. Butts this morning and some people who appear on panels on television.
What are you insinuating?
I'm not insinuating anything. I'm saying
you are
it flat
insinuating.
out.
What are you
I'm
insinuating?
asking you who wrote that for you, Mr. Wernick.
I wrote it on my computer after conversations with my counsel.
Okay, so that wasn't so hard to say. I'm wondering if I could read to you, Mr. Wernick, what Jody Wilson-Raybould said in her testimony. She said, the clerk of the Privy Council would have known on September 17th meeting because I specifically mentioned to both him and the Prime Minister going into detail about the Section 13 notice that I received, and that, again, I was very clear that I have already made my decision around the deferred prosecution agreement and not intervening. There's no reason not to take that as a fact, is there?
As I testified last time, 90% of the conversation at that meeting and the reason for my presence was to discuss the Indigenous agenda.
I didn't ask about that. I asked you whether or not that's a fact in your mind now. Is that an agreed fact between you and I that on September 17th she went into detail about the Section 13 notice? Or do you not remember it now?
I do not believe that it was in detail or lengthy. She made her position clear as she testified that in her mind she had made a final decision.
We heard in great testimony, I'm going to actually ask the Deputy Minister of Justice a question right now. We heard in great detail from Jody Wilson-Raybould's testimony some things that I found quite disturbing as a lawyer. And I'm just going to tell you what they are. And I understand fully that you were directed on September 19th not to have any discussions with the Director of Public Prosecutions, and you didn't. And I accept that. But on September 16th, two members of PMO said that individual Crown prosecutor wanted to negotiate an agreement, but the director did not. They also said that they heard that you, the Deputy Minister, think she can get the PPSC to say, we think that we should get outside advice. And on the 19th, the same two from PMO raised the idea of an informal reach out to the director, either through the Attorney General staff or through yourself. Do you believe that direct contact between staff of the Prime Minister's office with your Crown prosecutors or the Director of Public Prosecutions or the Public Prosecution Service is appropriate?
I don't think so, but I'm not sure this is what we should read on that they had conversation with public prosecutors.
Well, we'll treat it as a hypothetical. Do you think it's appropriate for that kind of contact to happen between the Prime Minister's office staff and your Crown prosecutor or the PPSC of Canada?
That was the last question. The witness has time to answer. So
Crown prosecutors don't have conversation about specific cases with PMO. They can maybe answer questions, but as I said before, the Section 13 to explain are really dedicated to the AG.
Yeah, sorry.
Conversation.
That was okay. So now we'll go to Mr. Boissonneau.
Thank you very much, Mr. Chair. Madame Drouin, merci d'être ici.
Thank you, Ms. Drouin, for being with us today. As you know, I'm not a lawyer, so I'd like to specify a few things you said in your testimony for things to be very clear for me and perhaps for others as well. And I'm going to do this in English.
At the end of October, the Privy Council office asked you, your department, for an opinion on the potential impacts on the SNC-Lavalin issue if the prosecution were to lead to a criminal conviction. Is that yes or no?
Yes.
Did you develop that report, yes or no?
My department developed it, yes.
Would that report be considered legal advice?
Yes.
Did you provide that report to the Privy Council office?
No, I didn't.
Why did you not provide that report to the Privy Council office?
Because I knew my minister was not, comfortable for us continuing those conversations. I felt that I should test with her office before share it the piece with the Privy Council office, and I was instructed not to send it.
So the Minister of Justice and former Attorney General of Canada instructed you to not send your legal advice to the Privy Council office and, by extension of that, Cabinet. Well,
the request I got from PCO, and I'm accountable to the minister. I do also report to the clerk on the management thing, but I decided that because my minister was not comfortable with us sharing with PCO, I didn't.
Let me simplify the question. You did not provide the report to PCO at the request of your minister.
That's right.
Mr. Wernick, I appreciate all that you've done for this country and your contribution to the institutions of governance in Canada. If a report such as this were shared with Privy Council office, is it reasonable to assume that that information would at some point be shared with Cabinet in a deliberation?
The matter of prosecutions would never come before Cabinet.
Would it be something that an Attorney General might discuss with the Prime Minister, or at least need to be informed about before she met with the Prime Minister?
I think that certainly my understanding of the law, and we've talked about the Shawcross principle, is that the Attorney General, as the final decision maker, has the ability and sometimes the obligation to seek input from colleagues.
So, Madame Drouin, pour préciser encore une fois,
just to specify things once again.
The former Attorney General went into a meeting with the Prime Minister on September 17th without the benefit of your full advice on whether to pursue independent legal advice.
Well, on December 17, she was in possession of the legal opinion I described in my opening remarks.
Okay. This is a key point because she instructed you to not raise the matter of SNC anymore. How do you reconcile this with her legal and professional responsibility to consider public policy interests, such as the impact on jobs and other considerations that we've heard here?
I mean, I think it's for her to answer that. I would like to offer that she said last week that she did her due diligence when she received a Section 13 letter. In the legal opinion that I described, we say that the first thing for an AG is really to make sure that she has all the information she needs to take her decision.
Okay, so according to your testimony then, the former minister and AG instructed the Department of Justice not to discuss, consult, or consider anything related to SNC-Lavalin after September 19th. In your opinion, did that impede the government's ability to seek legal advice on a new policy tool? And did that obstruct the government's ability to advocate lawfully for jobs? Premièrement, did that affect the government's ability to get an external opinion on a new policy tool?
Le gouvernement peut toujours aller.
The government can always seek opinions when it is developing a new program, but only with the approval of the Attorney General. If your question is whether the government will seek legal advice on a criminal file in particular, the opinion I said was that even if it was suggested to seek outside legal advice, we would recommend transparency and a publication of this advice in the Canada Gazette. The fact that the former Attorney General said that she didn't want any more work on this file, did this prevent the government from seeking other legal advice on the SNC file? She is the person who decides on this file. And when she makes her decision, it means that the door is closed. She's the only one who can decide to exercise her powers under the DPP Act.
Here and provincially, is it a usual course of business or normal for an Attorney General to not forward a legal advice to the equivalent of the Privy Council, whether it's provincially or here at the federal government?
Comme je l'ai dit, je suis...
As I said, I am accountable to the minister and also to other ministers, including the Prime Minister. And if I do receive instructions, I act accordingly. Thank you.
December 19th, there was lots being said there. You mentioned, and it's been mentioned in testimony, that the Prime Minister and the former Minister were at loggerheads over issues. Were they at loggerheads over an issue, any other issue other than SNC-Lavalin? Was there something else at play here?
I'm not sure that's a question I should answer because it's not covered by the SNC question.
Is there an issue that they were at loggerheads over other than SNC-Lavalin?
I think, and I do not have contemporaneous notes of the conversation. I would not say they were at loggerheads. I was worried as a Secretary of Cabinet that frustration was building, that colleagues and the Prime Minister had not been provided an explanation for why the DP8 route or option was not being chosen or exercised, and why seeking outside counsel to do due diligence on the first use of a DP8 was not being chosen. There was building frustration at the time, and I was concerned about that. The smooth functioning of Cabinet requires that ministers have a good working relationship with each other.
Thank you very much.
Thank you very much, Mr. Rankin.
Before my time starts, I just want to put on the record that I have a motion to make at the end of the proceedings again, if I may. Okay, I have a couple questions for Mr. Wernick and a couple questions for Ms. Drouin. From you, Mr. Wernick, picking up on what in the last round, I asked you a number of questions about the call you made on September the 19th to the former Attorney General, December 19th. Yes, and thank you. And you said you didn't recall a number of things I asked you. Now, we have as a fact that the Honourable Jody Wilson-Raybould and Dr. Philpott quit their jobs. They resigned from Cabinet. And you're telling Canadians that you don't remember saying any of the key things that the former Attorney General testified to. So my question is, how can you expect Canadians to believe that these highly competent, highly credible women got this so wrong?
I think there's a few plot holes in the question. It is very clear from the sequence events that whatever triggered the Minister Raybould-Wilson's resignation happened after she was moved and after the appearance of the Globe and Mail story.
Okay. I have another one for you, and this goes to your experience in setting up fair process as a clerk, and over your 37 years as a public servant, you've seen the need for fairness in public institutions. My question is this: do you think it's fair that the Liberals on this committee voted to invite you back to address the testimony of Jody Wilson-Raybould, but they just voted against extending her the same courtesy?
I think this is entirely for the committee to decide.
So you have no opinion, based on your vast experience with agencies, boards, and commissions, whether that's a fair process?
I work for the executive, and I will not opine on how Parliament should conduct its business.
Okay. I'd like to turn then, if I could, to Ms. Drouin. In your account, you referred to September 19th, and you write the following: I clearly recall that the former Attorney General said to me that this would be the last time we discussed the SNC-Lavalin matter, and she instructed me to not have any discussion with the DPP, close quote. So she had decided by that day. It seems clear from your testimony that you agreed to that. So unless there was any new evidence, why would one continue to raise this matter with her over and over again? Now, we heard it said that the Attorney General's decision is never final. But if there's no new evidence, no new facts, which I think you replied to Mr. Assassi on, why would that be appropriate to keep going at her when she said, and you record in your testimony, that she had made up her mind on that date?
Maybe one thing. So I cannot say whether or not new evidence, new facts was under the government hands at that point.
It was helpful, Mr. Rankin. I firmly believe there were new facts that emerged between September and December.
Well, that's new evidence that's not been brought to this table before. And I understood you replied as a lawyer to a question from Mr. Assassi that it had to do with whether there were new facts or evidence. That's what you said.
I said.
Are you telling us there is any new fact and evidence? I understand that Mr. Wernick believes there are. What would that evidence be?
I said that I cannot talk about.
You can't talk about it.
I mean, not that I can't.
Can anybody talk about it?
No.
You don't know.
I don't know if new facts or new evidence
I know I'm
were
sure
available at that time.
That's good to know.
And Mr. Wernick is ready to answer that question if you want.
I asked the question of Ms. Drouin. Am I going to be docked on my time, Chair, as a consequence?
Go ahead. If you don't want to, please go ahead.
Well, I'm happy to have him reply if it's not costing me the very scarce seconds I have.
Well, now so I'm going to stop it for a second. But no, that you should proceed with your time how you want. He offered to answer.
I'm offering Mr. Wernick, who wishes to intervene, the opportunity to do so.
The new facts that emerged, which I believe were public interest considerations, were the tanking of the share price of the company, making it vulnerable to takeovers, and communications from the new Premier of Quebec and the Government of Quebec, which changed the risk calculus around a conviction or not conviction of the company.
All right. Thank you very much. And I apologize, we're just under such constraints. That's the way the process works. We had the testimony of a former judge here, Ms. Drouin. Her name was Mary Ellen Turpel-Lafond. And she called for an RCMP investigation into this affair if there was any evidence that Ms. Wilson-Raybould was removed as Attorney General because she refused under pressure to change her position in favor of a deferred prosecution agreement. Do you agree with the former judge?
I think what I have to say is what I've seen in that case, and I do have an ethical obligation. If I had seen illegal activities, it was my duty and responsibility to report it, and I have not reported anything.
Is that it, or we? I'm going to ask Mr. Angus.
Well, just finally, because Mr. Butts claimed there was new evidence, which would be reason to intervene in a direct public prosecution. But Mr. Wernick, you said this new evidence consisted of SNC's share price. When the Prime Minister's office wrote that legislation, they specifically exempted the economic argument. So Ms. Wilson-Raybould was very clear that this could not be. And yet you believe that if it's something that you think can happen, well, we'll just make it happen. If economic argument was written by the Prime Minister's office as not allowable, how do you get to claim that's new? That's not new evidence. That's new opinion.
So the phrase national economic interest in the legislation is a cut and paste from the OECD code on anti-bribery. And it is meant, in my understanding, and you can seek advice on this from experts, to distinguish national economic interest from the interest of other countries. So you can't, if you're part of this group in the OECD, you cannot favor or let a company off because it helps France versus Germany or Germany versus Italy or Canada versus the United States.
But it could be perfectly fine used in an election.
So if I could finish the question,
then the time has expired.
My view is that the economic impacts of jobs, and it's explicitly in the criminal code, the impact on suppliers, pensioners, customers, communities, is a relevant public interest consideration.
Very much. Ms. Khaled.
Thank you, Chair. And just to start off, Mr. Wernick, things that you can talk about today, is it true that you would not have been able to talk about those same things at the last time that you were before the committee, and now you're able to talk about them because of the Ordering Council?
Yeah, there's one thing specifically, which is the legal opinion which I sought and obtained in October, which I am now at liberty to share with the committee.
Thank you. I'd like to turn to the September 19th one-on-one meeting. The former Attorney General said that you raised the fact that a board meeting was to take place on September 20th with stockholders, and she deemed this to be inappropriate. She also claimed that you raised the issue of SNC's lawyer, Frank Iacobucci, not being a shrinking violet, which she also felt was inappropriate. Did you raise those issues, and do you consider raising them to be appropriate?
I don't remember the terminology. I know Mr. Justice Iacobucci because we worked on a committee together, which was the selection committee that chose the head of the Truth and Reconciliation Committee. And I was aware of him because I attended University of Toronto when he was Dean of Law and so on. If I used a phrase, I think it was intended to convey that I knew Mr. Iacobucci by reputation and somewhat personally, and he is an extremely tough legal mind.
Why were you concerned about the September 20th meeting of the SNC board?
I think I explained this earlier. It's not so much the board meeting. The board would make decisions about divulgation to shareholders and the public. They are a publicly traded company that regularly would have obligations to markets. And what they told the market would have repercussions. So the board, obviously for a company that was headed for a criminal trial, was continually, as the stewards of the company and with responsibilities to shareholders, constantly reassessing its options.
And why did you think that this was relevant information to share?
I think that I was of the view, and I remain of the view, that the potential impact on 9,000 people, the suppliers, the customers, and the communities is a relevant public interest consideration.
Now, the former Attorney General wouldn't further consider anything that you raised at the September 19th meeting, indicating that should SNC draft a letter expressing their concerns, she would forward it to the DPP. So at that point, would you say that the Attorney General had made up her mind? And from your conversations, what, if anything, would have changed her mind?
So September 19th was the first opportunity for me to follow up on September 17th. That was the week Parliament came back, as I'm sure all of you remember. And the first chance to go and see her was after National Caucus ended on Wednesday. We met in her office for about 10 to 15 minutes, in my recollection. We had a conversation which is along the lines of what the former minister testified when she was here. She was very firm that in her mind it was final, and the only route open was for the company to make public interest arguments through its lawyers. And that's where I left the matter.
Thank you. And just going towards the September 17th meeting with the Prime Minister, and you were present there, Ms. Wilson-Raybould did indicate in her testimony that the reason for the meeting was not SNC, and you confirmed that in your testimony as well. Can you talk about what 90% of the meeting was, as per your testimony?
February, I think it may have even been Valentine's Day of 2018, the Prime Minister spoke in the House and committed his government to a new approach to recognition of Indigenous rights. Fundamental change in the relationship. And it's something that he wanted to do, and I'm sure would like to still pursue. Through the course of the summer, we were not making progress on ironing out the public policy and legal considerations around that. And I was in trying to keep the agenda moving through the fall, which included NAFTA, legalization and regulation of cannabis, and many, many, many other issues. I stepped in to try and conciliate and move that forward. My colleagues at PMO were immersed 7/24 in NAFTA negotiations.
Thank you. And one question to both of the witnesses. There have been comments made about the possible separation of the Attorney General and the Minister of Justice, the separation of the roles. Can you please both comment on the feasibility or whether this is a step that we should take?
I think that when you're considering a change of that magnitude, you are not talking about changing an app. You are talking about going into the deep code and the operating system of this country, and it should not be done lightly. It should be studied thoroughly. I think parties should declare themselves in the upcoming election. It might be a good topic for an expert panel, a royal commission, a Senate committee that's not running for election this summer. I do have views, which I'd be happy to share at the time. But my view is that I wouldn't do it lightly. And the UK analogy is not a perfect one because the United Kingdom does not have a statutory wall around the prosecutorial function, and Canada does.
If I can add, I've been working with that system for 6 years. I think it's a good system. I think it's working. Whether or not something else can be, brought in Canada is a policy question, and I'm ready to support doing analysis if there's a need to do that.
Thank you. Thank you very much. So we'll now go to 3 minutes from each of the non-recognized parties, and then we'll excuse the witnesses, and then we'll come back to Mr. Rankin for his motion. So Ms. May.
Thank you. I do identify myself to Mr. Wernick as someone who has stated publicly that he transgressed the line. I think I would suggest to him maybe he can agree that when we use the word partisan, I would never suggest for a moment, Mr. Wernick, that you were a strong lifetime liberal or a strong lifetime conservative. I think your evidence is consistent with being willing to interfere in partisan fashion for whoever is in power. But my question to you is, had you ever met Frank Iacobucci in the context of anything in the 4 months that have been described to us by Jody Wilson-Raybell's testimony? Did you have a chance to talk to him in that 4-month period about anything?
No, I do remember that he attended the Sherbrooke cabinet meeting, as I did. I crossed him in the hall. I came over and greeted him because I know him. I have never had a conversation with Mr. Justice Iacobucci about these matters.
Okay. Now, of course, in your previous history of public service, for a remarkably long time, you were Deputy Minister at the Department of Indian and Northern Affairs, and our former Attorney General, of course, was a prominent Indigenous leader with the BC Council of Indian Chiefs. I just wondered, did you have any relationship with her prior to her time as Attorney General in that context?
Yes. I met her as early as 2006 when I started working at INAC. I attended BC Chiefs Assemblies. I was a co-panelist with her on academic conferences. I was a co-panelist with her at a number of meetings. We've had breakfasts, lunches. We've had an ongoing conversation. I had relationships with Indigenous leaders right across the country in order to do my job. And as I said in my testimony, I considered the former minister an ally in what we were trying to accomplish, a colleague and a friend.
Now, in the context of your evidence here today, I wonder if we did have the discussion about it being cut and paste language from the UNESCO agreements about OECD rather, about the OECD agreements about how to understand the term national economic interest. But it is clear that Section 715 sub 32 sub 3 says that the public prosecution must not consider the national economic interest as a factor. Isn't it a fair inference from that you would not consider a jobs argument in deciding whether to bring a public prosecution or not?
That's not my reading of the law. My understanding is in this context, national economic interest means domestic, as opposed to the interests of other countries. And I repeat that I believe that the impacts on jobs, suppliers, customers, pensioners, and communities are a legitimate public interest consideration.
So in the public interest then, Mr. Wernick, in preparing advice to Cabinet, what work did you do to assess the threat to jobs? Did you look at the commitments made to the Government of Quebec not to move headquarters, as mentioned? Did you look at the current financial status of SNC-Lavalin? Did you, in fact, have an independent assessment of whether there would be any impact on jobs from a decision to proceed as the Director of Public Prosecutions had decided to proceed?
No, because the file was entirely in the carriage of the Minister of Justice.
So, sorry. That time has expired. Monsieur Plamondon.
Merci, Monsieur le Président.
Thank you, Chair. Earlier, we talked about the PCO's request regarding legal advice that you prepared, and you said earlier, and you said that you did not send it to the PCO at the request of the minister, and now that the minister is no longer in place, could you send this legal advice to us so if the committee could take it into account? You're talking about the legal opinion on the impact if SNC were found guilty. I will look at your request and I'll ask for advice before I provide it, because it is still the draft and I will have to take some advice before I reply. But I will make the commitment to examine this possibility. Since the beginning of our discussions, well, the minister, within 8 days after she came back from her trip, to paint herself into a corner, she said that she is going to prosecute them and then she'll take no more advice or occasions to take outside legal advice. And that she wouldn't listen to anyone, and she was stubborn. She said, I'm going to prosecute them. And then later, SNC-Lavalin lost $1.6 billion over 3 months. Its share price fell by 30%. And that didn't give her cause to reflect once again on this issue. And can you give us an explanation or a reason why she was so firm in her decision and she didn't want to listen to anyone? I said earlier, for the minister and for AGs, it's very important to respect the independence of their role. And that's why they really protect their decisionary power. And I answered the question saying that, in my opinion, based on what I understood, is that she didn't see that there was any leeway in exercising her powers under the Act of DPP, that this would not be perceived as political influence. Even if she voted in favor of the Act, there are two components here. First, the Act, which introduced into the criminal code the whole system for remediation agreements. It was a tool that was given to the Director of Criminal Prosecutions. And this was an option that the minister proposed, whether she could exercise her power under the DPP Act to overturn or to intervene in a decision that was made by the DPP to not offer a remediation agreement. We're going to move on to the next question.
Thanks very much. Mr. Wernick, in your opening statement, you indicated the former minister agreed that entering into a deferred prosecution agreement would have been entirely lawful. My understanding of Ms. Wilson-Raybould's testimony is that she did not believe that SNC-Lavalin was eligible for a deferred prosecution agreement under Canadian law. So I wonder if either or both of you could shed any further light on whether SNC-Lavalin would have been eligible for that provision.
What I meant by lawful was it was an option available to the minister under legislation passed by this Parliament. There was nothing illegal about a deferred prosecution agreement. It's a lawful instrument and an option that was always and still is available to the Minister of Justice.
No, fair enough, but either you or Ms. Drouin have any view on whether SNC-Lavalin would have qualified for the provision that is in legislation?
I have no line of sight to the evidence and the arguments. That is a decision which is entirely 100% in the hands of the DPP and the Minister.
Maybe just to add, so the offenses SNC-Lavalin is facing are covered under the remediation agreement regime. But as the clerk said, whether or not this tool is available on a specific case is the decision of the DPP.
Okay. On the possibility of separating the Minister of Justice portfolio from the Attorney General portfolio, Mr. Wernick, you said that it's not a decision to be taken lightly, that there should be more study, and that you might have views to present as part of such a study. Given that you're in charge of the machinery of government in this country, I'm wondering if you have any views that you could present today.
I think if you're going to go down this road, and I do think it's a productive thing to go down, then you'd have to look at Australia, New Zealand, the United Kingdom, provincial governments, and ask yourself, where is it being done, where is it not being done? My general comment on machinery changes is you trade one set of issues for another set of issues. There are consequences that are intended, and there are unintended consequences. And the people that make decisions on machinery, which actually is you in passing legislation, have to decide which set of issues you'd prefer to have.
Okay. It must happen on a fairly regular basis that companies come to the government seeking certain concessions and saying that there will be dire economic consequences and job losses if they don't get what they want. I'm wondering if you can speak any more to how the government assesses those kinds of claims or threats from companies.
Well, first of all, I mean, it's an opportunity, thank you for the question, to say something I said earlier, which is in Canada, we have a very strong transparency regime, that these contacts with government and this advocacy by companies is recorded, it's registered, and it's regulated. So that is a very good thing for Canada and Canadians. Companies, unions, university presidents, provinces, stakeholders make representations to governments all the time, and they make them to you. And so each issue would be different in terms of how it's assessed.
Okay, well, thank you.
Thank you very much, Mr. Weir. So as not to confuse anyone with what's going to happen, I propose that I will thank the witnesses, excuse the witnesses. We'll suspend for 2 minutes so that the witnesses can leave, and then we will move to Mr. Rankin's motion.
Mr. Chair, can I just clarify one point about availability of documents, because I'm trying very hard to be helpful to the committee?
Of course.
So, because I was never asked the question directly, but I just volunteered to try to be helpful to the committee, that as this issue started to bubble in September and October, I, like many people, wanted to understand the decision-making framework. Who had what role, what authority, and what power? I verbally asked my colleague for a backgrounder on the issue. That backgrounder was sent to me on October 12th in the afternoon, and I am now free to provide that to the committee. That opinion, which gave no opinion on what to do, it's simply a backgrounder on roles, responsibilities, and authorities, has been the foundation for my participation in this file ever since.
Thank you very much. We'll consider it tabled with the committee. Ms. Reid, before I thank them, did you want to ask something or say?
To know whether or not anybody would be interested in having very short one more round, 3 minutes each.
I'll look around. So it looks like we'll have to have a vote on that because I don't see consent.
The meeting was scheduled for 4 o'clock. We're 15, and our witnesses have been good.
Okay, so do you want to propose? Yeah.
Yes.
Okay.
I want to get to the bottom of stuff, okay?
Okay, well, in any case, I would like to then take this opportunity to thank both witnesses, both for your service to Canada and your willingness to come forward to the committee twice at a time when you're under a national spotlight. The men and women of Canada's public service across the country do an incredible job for all of us, and I know that we all, from all parties in Parliament, appreciate our public service. Et j'aimerais vraiment remercier tout le monde dans la
I'd like to thank everyone in the Canadian Public Service.
Thank you so much. We will suspend for 2 minutes and let the witnesses walk out. Thank you.
Merci, Monsieur le Président.
Thank you, Chair.
The clerk has asked me to just clarify one thing again. The document that the clerk just tabled is in English only. Would we have permission to circulate it again? Et on va faire la traduction après?
And we'll do the translation afterwards, or would you prefer not to have it until it's translated? Chair?
He provided that he received from the Justice Department on solicitor client. Sorry.
How much time will it take to translate it? Well, it's roughly 2.5 pages. Clerk, how much time should it take? It's the same things I said earlier. I'm somewhat surprised. We should have this in both official languages. I don't want to object. I've been here on the Hill for 25 years, and I've understood for quite some time that, and the two official languages are English and their translation. But it depends who the witness is. But I agree entirely that we have to translate it. Mr. Berthold, Chair, since this cause does come from the Clerk of the Privy Council, I would assume that this person would be very aware of the obligations in terms of what happens here in the committee. And in this case, we will wait for the translation of this document. It's perfect. If you're not in a rush, we'll wait for the translation, and we'll wait for it to be translated probably next week around Tuesday or Thursday. All right? Perfect.
Chair, I look to you for guidance as to the receivability of the following motion, but I'll read it and then explain why I believe it's critical. My motion is that the Committee A call on the Prime Minister to amend the Order in Council number 2019-0105 to allow the former Attorney General to speak openly about any matter salient to the SNC-Lavalin matter after January 14th, and to call as witnesses as soon as possible the following 4 individuals: Jessica Prince, former Chief of Staff to Ms. Wilson-Raybould; Katie Telford, Chief of Staff to the Prime Minister; Elder Marquez, Senior Advisor to the Prime Minister; and Mathieu Bouchard, Senior Advisor to the Prime Minister. Mr. Chair, the reason I think this is so important, if I may, is that there were 2 meetings that we heard a lot about today. One, November the 22nd, where Madam Wilson-Raybould met with Mr. Bouchard and Mr. Elder. And then there was a second meeting that her Chief of Staff took with Katie Telford. I think it's really important from a matter of natural justice and fairness to those individuals that we hear from them. Let me explain why. It's hearsay what Ms. Prince recorded about her conversation. And with respect, she said some very disturbing things attributed to Ms. Telford, namely that we don't want to debate legalities anymore, direct quote. Now, in fairness to Ms. Telford, we need to have her here. And we need to have also Ms. Prince here so we can get at the bottom of that, what appears to be a very serious issue. I think it's fair to both of them to do it. I think it's grossly unfair to not have that testimony. And lastly, when it comes to the November 22nd meeting with Mr. Bouchard, Mr. Marcus, and the former Attorney General, there was some very serious things said about enough is enough. I keep saying no, I've made up my mind, etc., and yet we know what transpired thereafter. My point is, fairness requires that we hear these witnesses. And as to the first part of the motion, it seems grossly unfair, with all due respect, that we were allowing Mr. Butts to come and talk about what happened after she was removed from Cabinet, but she can't do so. So my plea to this committee is in the interest of fairness that we allow this to occur.
Thank you very much. The motion is receivable. There's no problem. Yeah, we'll get a speakers list. I would just note, I don't believe he spoke about the period after she became the Veterans Affairs Minister. He was speaking about the period.
He talked about when she was removed from Cabinet today.
We'll have to all look at the transcript. I think he was largely talking about the period in between the 2 ministers, during the shuffle period, which was before the new appointment. But we'll all have to look at that. So in any case, the motion is receivable. And can I just get a speakers list? Who wants to intervene? I have Mr. Polyev, Mr. Fraser, Ms. Raitt, Mr. Cooper. Okay. Mr. Berthold après. Sorry, Mr. Polyev?
Yes, Mr. Chair, it's necessary for Madame Jody Wilson-Raybould to return. We now have contradictions between witnesses. Another good reason why we should have allowed them to swear an oath before they spoke. I still don't understand the government's objection to having people swear an oath and assert that they will be truthful. But what contradiction worries me the most is that...
Can I just understand, are you moving an amendment right now to Mr. Rankin's motion?
No, I'm speaking to the motion. You said...
But the motion doesn't involve Ms. Wilson-Raybould.
Sorry, I misunderstood then. I thought the motion did involve Mr.
No.
Okay, I apologize.
I moved that motion this morning, and I was defeated by the Liberal majority, Mr. Polyev.
Okay.
I'm now asking for 4 witnesses, separate from that particular witness, to come forward.
Okay, I move the amendment that Ms. Jody Wilson-Raybould be recalled, and that the committee call on the government to release any further, release her to tell any further information that happened after she was named Veterans Affairs Minister. Thank you. That's my amendment.
I understand that. So the subsection A of the motion already deals with that issue. You're proposing to add an E and say Jody Wilson-Raybould, former Attorney General, Minister of Justice. Was the meeting this morning separate from the meeting this afternoon? Okay. So that's the amendment. Mr. Polyev's amendment is on the floor. Okay. Ms. Raitt?
Speaking to the amendment?
Sure.
Ms. Wilson-Raybould has sent a statement to the media this afternoon indicating she would be willing to reappear at the committee. I think as a result, she is clearly doing what Mr. Butts did last week, which was asking for an opportunity. So that's why we moved the amendment to make sure that we were able to consider this with the new evidence that has recently arisen.
Mr. Fraser? Well, you had the floor, and then it went to Ms. Raitt. I'll come back to you.
Thank you.
Okay, so Mr. Fraser has given you his... We'll go back to Mr. Fraser. Who's next? Mr. Polyev?
Thank you, Mr. Fraser. I appreciate that. Ms. Wilson-Raybould testified that both the clerk and the Prime Minister on multiple occasions and on separate dates told her that if she did not immediately proceed towards a deferred prosecution agreement to shelve the charges against SNC-Lavalin, that the company would move its headquarters out of Montreal. We know that's impossible because of a loan agreement between the company and the Caisse de Dépôt that is part of a $1.5 billion financing deal. So somebody would have been telling her a blatant falsehood in an attempt to get her to sign the deferred prosecution agreement with false information. Now, today, Mr. Wernick denied having said that. Ms. Wilson-Raybould's testimony alleges that he did say it on two separate occasions, once in September and then once again in December. So we have a major divergence of factual accounts between these two witnesses. Mr. Wernick has been given a second chance to come back and testify, whereas Ms. Wilson-Raybould has not. She would have a stronger case for returning because, as we all know, she was prohibited from telling her entire story when she first came before the committee. So the government must release her, eliminate completely the gag order that prevents her from telling the whole truth so that she can come back. And I will close by returning to my first point. It has been alleged, and I argue been proven, that members of the Prime Minister's inner circle pressured Madam Wilson-Raybould into making a decision she did not want to make. However, it may be more serious than that. If the Prime Minister, the Clerk of the Privy Council, and other senior staff deliberately told a falsehood to Canada's top law officer to trick her into shelving criminal charges, then that could rise to a higher level of criminal conduct. And we have significant evidence that such a claim was made by those officials, including the Prime Minister, to Madam Wilson-Raybould. It is incumbent upon us to have her come back here, now that Mr. Wernick has had an opportunity to contradict her, and tell her side of the story. Thank you.
Thank you. I'll just note again, for the purposes of the record, the amendment is going to be deemed to be made by Ms. Raitt because she put up her hand after, and Mr. Polyev is not a member of the committee, so he can't put an amendment. So the amendment is, yeah. So, Mr. Fraser?
Thanks very much, Mr. Chair. A few things here. I mean, the way that the committee has functioned on these meetings up to this point is in a step-by-step fashion in order to determine the next steps, in order to determine what we've learned at the various meetings regarding the testimony, and then to have a subsequent meeting involving next steps. I know that was the motion that convened to the parameters of today's meeting, was in order for us to hear the testimonies today, have an opportunity to reflect on it, and then at the following meeting determine the way forward for the committee, including whatever next steps may follow, and in previous times we've done that. We've seen further witnesses come forward. I note a couple of things. I note, first of all, that Ms. Jody Wilson-Raybould had the order in council, which allowed her to speak to a number of things that were not able to be spoken about by Ms. Drouin and Mr. Wernick the last time that they were here. And so that was one of the main reasons to have them back. I recognize as well Ms. Jody Wilson-Raybould had the opportunity to have an extensive opening statement, and that was obviously given to Mr. Butts today as well. But also, I think she testified for a period of about 4 hours. So it's obvious we have a lot of information before us now as a committee. My suggestion is that we reflect on today's testimony and do what the motion convening today's meeting had anticipated, which is at the next meeting, determine the next steps. So I think for all of those reasons, it's important for us to see that next meeting be when we come back on March 18th and determine where we go from there. So for those reasons, I'm asking to put consideration of the motion over to that date.
How would okay. So unless that proposal is acceptable, what we would need to do is deal with the current amendment with Ms. Reid and then move back to another amendment from Mr. Fraser to defer it to March the 18th. Is that March 19th? March the 19th, Tuesday, March the 19th at 8:40. Mr. Rankin?
I'd like to respond to
sure, of course.
my friend Mr. Fraser, but I just want to make sure I understand what we're voting on. Are we voting first on the amendment, namely that Ms. Wilson-Raybould be invited to return? Or are we talking
unfortunately,
about the main motion?
What I'm told is because that would you can't sort of because that was not unless you would say just one question. Would you have considered that to be a friendly amendment to the original motion?
Indeed.
So then, can we consider it? Okay, Mr. Clerk, as opposed to making it an amendment, Mr. Rankin considers it a friendly amendment to the original motion. So can we just consider it incorporated into the original motion? So we're adding one other witness into the original motion. Now, Mr. Fraser is suggesting to defer that until Tuesday, the 19th.
And that is what I wanted to respond to.
So that works perfectly because then we can deal with it that way.
Well,
and then, well, no, I'm not sure everybody's in agreement, but I think that at least we know what's on the floor now. So there was a motion. Ms. Wilson-Raybould is now incorporated as one of the people on the list of the motion, and Mr. Fraser is asking for it to be deferred until the 19th. And so that's the amendment on the floor right now, is Mr. Fraser's amendment. And now I'm going to come back to the speakers list. Mr. Cooper, Mr. Berthold, and Mr. Rankin are next on the speakers list.
Yes. Okay.
Yeah.
Well, thank you, Mr. Chair, and Mr. Fraser suggests that we reflect on this behind closed doors instead of before the public. That has been a consistent way that Liberal MPs have approached these issues. At every step of the way, they have tried to block, obstruct hearing from witnesses until they really feel that they have no choice. It may be, and it may very well be, that we need to hear from additional witnesses, but in the face of the testimony of today, it is inconceivable to think that we would not hear from Jessica Prince, Katie Telford, Elder Marquez, and Matthew Bouchard. Mr. Butts, very conveniently, we heard from Mr. Butts, who spoke to his version of events on the December 18th meeting. And so it seems perfectly appropriate, in fact necessary, to hear from the two other witnesses, two other participants at that meeting, Ms. Prince and Ms. Telford. It's completely clear that Elder Marquez and Matthew Bouchard repeatedly met with or communicated with Jody Wilson-Raybould's Chief of Staff and Jody Wilson-Raybould herself, including on November 22nd, but at other dates with her Chief of Staff, including October 18th and October 26th, to pressure or to reiterate the need for, among other things, an outside opinion. So how can we not hear from those individuals in order to understand exactly what was discussed and in order to understand the full context. And as for Ms. Wilson-Raybould, it is absolutely clear that we need to hear from her about the period after she was fired as the former Attorney General. And as Mr. Poilievre said, it is all the more important in light of her testimony that on two occasions the Prime Minister and the Clerk of the Privy Council raised an impossibility with her, and that is that SNC-Lavalin would be moving its headquarters. And Mr. Wernick, after being questioned by Mr. Poilievre for about 5 minutes, dodged his straightforward question about whether or not he had ever said that, and then he flat out denied that he ever said it, contradicting himself when he appeared before our committee last, where he stated, quote, that we openly discussed about the company moving or closing. That was his characterization of what took place at the meeting with Jody Wilson-Raybould when she said that she was threatened not once, not twice, but 3 times by Mr. Wernick. He said 2 weeks ago that he talked about moving the company, and then after he was cornered, he suddenly issued a blanket denial. We need to hear from Jody Wilson-Raybould as well. So why delay, and why should we have to wait 13 days to make a decision? What we need is this process to continue in an expeditious fashion. There is no basis for why this should have to wait, this decision should have to wait another almost 2 weeks when it is so painfully obvious that all of these individuals, these 4 individuals, plus Jody Wilson-Raybould, are necessary to hear from in order to understand the full truth.
Monsieur Berthold?
Mr. Berthold, thank you very much, Chair. It was a real pleasure and honor to be with you today on this committee. I learned a lot, and unfortunately, there's still a lot to be said because we heard from Mr. Butts, and the Justice Committee accepted to hear the testimony of Mr. Butts right in the middle of a break week, and now there's going to be an amendment just to make a decision. So we're going to decide when we're going to hear a committee, and I find this a witness, and I find this unacceptable. Ms. Wilson-Raybould said on several occasions that she experienced veiled threats and undue pressure, and I heard testimony that this wasn't threats, that they were just requests that were made to ask for outside legal advice. So there's 2 totally different opinions here, and it's very rare in such a case when there's a conflict. When we ask the person who would have made the veiled threat to criticize themselves and say, oh, well, I didn't make a threat. When a person says that they were subject to undue pressure, it's usually that person you have to ask and believe their perception of the situation, and not the person who harassed them and asked them how they're managing a file, whether it was appropriate or not. I think we have to believe the person who received the inappropriate pressure. Chair, we were able to hear today Mr. Butts say that Ms. Wilson-Raybould demotion had nothing to do with the SNC-Lavalin affair. And this is not what we can infer based on everything that's happened. And we'd like to hear what Ms. Raybould has to say about this situation, because she wasn't authorized to talk about it. And this is totally unacceptable. We can't allow Mr. Butts tell us today that the demotion of the minister, the AG, had nothing to do with the SNC-Lavalin affair. And we have to allow Ms. Raybould to come and say whether she felt that this was directly related to this affair. Chair, in conclusion, in Ms. Wilson-Raybould's testimony, she often talked about veiled threats. And what is the biggest threat right now facing the cabinet? Well, that's facing losing her job, and that's to be demoted, to lose her position. Chair, if you looked at just the facts, Ms. Wilson-Raybould did lose her position. These veiled threats were real threats, Chair. And it's important to hear what Ms. Wilson-Raybould has to say, and we have to hear her as quickly as possible, and not just rely on the Liberals' political agenda. We owe it to Canadians to shed light on this as quickly as possible, and we owe it to Canadians to hear all the witnesses and the truth as quickly as possible. Thank you very much, Mr. Rankin.
Time to wrap it up soon, I appreciate, but I just want to say to my friend Mr. Fraser in response to his comments that yes, indeed, it has been our process to deal in camera with the selection of witnesses. That's the context, however, where we're trying to not embarrass people in public about which witness we choose, which expert we like over another. I think that's the purpose for which we've done that. I don't think it's written in stone. Now, the Liberals' motion was that we proceed step by step, all right, but I think we can agree that circumstances are a little different today. We have some serious testimony that seems to be contradicted, and I just think it's a matter of fairness to Ms. Katie Telford to defend herself, to be given an opportunity to confront the statement that I read into the record, that our witness, Ms. Wilson-Raybould, read into the record. And I think that if it's a question of her extensive statement, to which Mr. Fraser alluded that she did last time, and I'm happy to have her waive such a statement. We don't need it now. We're getting into the facts and so forth. So I think that the Liberals on the committee, if they vote down now an effort for us to tell Canadians we're going to continue to get to the truth of this, they're doing a disservice to our committee. They're doing a disservice to the notion of getting to the truth. I agree with Mr. Cooper. It's painfully obvious these witnesses must be heard. Let's just get on with it.
Very much, Mr. Rankin. Anybody on that side wish to respond? So basically, the clerk has written out the correct procedural amendment to give effect to what it is that Mr. Fraser suggested, which is that all the words after that be replaced by the following: the committee should consider next steps and potential additional witnesses on Tuesday, March 19, 2019, is what the clerk says is the correct procedural step. So, yeah. That all the words after that be replaced by the following: the committee should consider next steps and potential additional witnesses on Tuesday, March 19, 2019, is what the clerk says is the right way to do that amendment. So basic, yes. Of course. Thank you. Sorry, briefly suspended.
We're going to go back to the amendment, and here it is.
Follows that all the words after that be replaced by the following: the committee should consider next steps and potential additional witnesses on Tuesday, March 19, 2019. That is the amendment to give effect to what Mr. Fraser suggested. So the vote would be on the amendment, which would essentially replace the main motion, right?
That's my motion is no longer on the floor. Mr. Fraser's amended motion is what we're voting on.
That would be correct.
Only.
Well, the amendment would be what would be voted on. And then the main,
as amended or not?
but the amendment. Yeah, so we would vote on the amendment, and then the main motion would essentially be replaced by the amendment, and we would vote on that. So we'd vote on it twice. Yeah. Sorry, recorded vote on the amendment. Yeah. Yeah. But first is on the amendment. Yeah. So the recorded vote is on the amendment. So those in favor of Mr. Fraser's amendment would vote yes. Those who are against would vote no. Okay. Mr. Clerk.
Merci, Monsieur le Président. Alors,
Thank you, Chair.
Mr.
Essassi? I'm in French. I approve.
Yes.
Yes.
Mr. Essassi?
Yes. Enfin.
Mr. Fraser?
Yes.
Ms. Khalid?
Yes.
Mr. McKinnon?
Oui.
Mr. Barrett?
No.
Mr. Cooper? No. Ms. Reid?
No.
And Mr. Rankin?
No.
So yeas 4 and nays 5.
Yeas 5 and yeas 4. So the amendment is carried, and now we would vote on the motion as amended by Mr. Fraser's amendment.
That's right.
So another recorded vote was requested by Mr. Cooper. So, Mr. Clerk, now it's on the motion as amended.
Can you read that motion?
It would read exactly like it read before.
Monsieur Boissonneau?
Oui.
Mr. Isasi? Mr. Fraser?
Yes.
Ms. Khalid?
Yes.
Mr. McKinnon?
Yes.
Mr. Barrett?
No.
Mr. Cooper?
No.
Ms. Wright?
No.
And Mr. Rankin?
No.
So yeas 5, nays 4, 4.
So the motion is carried. Is there anything else? If not, colleagues, I wish you all a lovely rest of the day. Meeting adjourned.